Thank you, Sean. So good morning, everybody. I'm just going to switch my view here so I can see more people. I don't particularly like staring at my own face when I'm talking on Zoom. So welcome to the Otla Cup. I'm Mike Giordano. I'm going to host things today along with Sean. We're going to move things along throughout the day, hopefully as smoothly as possible. I know some people are having some issues with Zoom or power. If that's the case, you can also email Sean or I throughout the day. We do have backup links like he mentioned. And it's always inspiring to see us come together, even in a virtual environment. Good opportunity for all of us to develop our advocacy skills and get some valuable feedback from a real judge and real lawyers. And it's my understanding we're one of the few that have a trial level moot rather than an appeal level moot. So we get a lot of feedback that it's particularly valuable to be in a trial setting and actually practice your chief and cross and opening and closing. This is my 6th year doing this, third in the virtual setting, hopefully getting back into person next year. I just wanted to thank some of the sponsors this morning as well, because they do make it possible for us to get together, whether in person or over Zoom. And I have a list here that I just want to quickly thank. Shona Sullivan, Mary Grosso always helps with bringing this together every year. Bruce Hillier, Gluckstein Lawyers, Miriam Gorlashvili, Anish Kotek, and also to the award sponsors. We have 6 awards that we're giving out today. Will Davidson, Greg Munforton, Bond Law Office, Tim Boland, Bergeron Clifford, and Shona Sullivan. And last but not least, my firm, Advocacy Giordano, out of Toronto. So most importantly, as we commence the proceedings today, I'd like to introduce the judge. He's going to be presiding over the matters today. He's graciously devoted his time over the weekend to attend and share his knowledge and feedback with us to all of our benefit. His Honor is fairly familiar with our subject matter today. He's a quite remarkable person, as expected. He's a long-standing judge out of Windsor for over 10 years, as I understand it. And prior to his appointment, he was a sole practitioner out of Mississauga since the early 1980s. And he's a certified specialist in criminal law and also a former bencher on 2 occasions. Very knowledgeable, very experienced. We're lucky to have him here today. And we were talking before we commenced that he was also a small claims judge, some of which of his decisions gained some notoriety and were reported in the media, et cetera. So thank you very much. Welcome, Justice Carey. We're honored to have you here today, and we truly can't thank you enough. So with that, I think if Your Honor is satisfied, we will open the court and begin to call our first witnesses.
Yes, well, it's my great pleasure to be back as a judicial personage in this Otla Cup. I understand it's been actively taking place since 1996. Every year, I had the pleasure of being there in the Windsor Court in 2016, I believe. I have a Windsor connection, both having until recently been a full-time judge in Windsor, and I have a matter to finish up, so I'll be back in Windsor soon, but I'm now in the East region in Kingston, and am a proud member of the Windsor Law Class of 77, which was the 7th year. Some of us graduates who are also judges had a tour of the school, and those of you who are Windsor Law are most likely anxiously awaiting to get back into the school or into the school for the first time. And I understand both you've been virtual because of COVID, and as well as not having the law school. I understand Dillon Hall is being used right now, which is probably Windsor's most classic building. these moots are very important, and the practice that you get here, as well as the collegiality of 6 different law schools coming together, even virtually, is something that I think will really, if this is your first time, you'll find it a memorable and long-lasting special event in your lives. The schools that that have representatives sent here today are all have great reputations, and I expect that all of you are looking forward to getting back into actual classrooms, if you haven't already, or have been enjoying the actual classroom work after a couple of years of being virtual. I understand this event will be live next year. I'm not sure which school is sponsoring it, but it really is an important and valuable program that Otla has been producing for almost 25 years, or over 25 years. And I really do have to tip my hat to all the volunteers from Otla who have been involved probably from the end of last year's event to now in getting this together and working on the problems and getting coaches. I understand we have coaches that have a variety of backgrounds and experiences, and that's an important addition to the experiences that you're going to have. So that's all I have to say. I'm pleased to see so many smiling and faces on the screen. And one of the advantages of virtual is I get to see everybody close up, and in some ways, and we can talk about this at another time, the virtual trial has advantages that over the actual trial. Certainly the judge gets a better view of the witnesses, and the lawyers are a lot closer. So if you have failing eyesight like I do, that's an advantage. So thank you all for your attentiveness, and as they say at the Olympics, let the games begin.
Thank you, Your Honor. I agree. It's a true reflection of our post-COVID practice to be in a virtual setting. That being said, just to all the participants right before we get started, when you come on, please state your name clearly. I know that there is your names under your profile, but that's not always visible or easily visible by the court or His Honor. Also, state the school that you're from and the party that you represent, so that we can take note of that, and just pause very briefly after you do that so we can note it down. And usually His Honor is writing something down about the person who's appearing before him. So good luck, enjoy, have fun, and Your Honor, if it pleases the court, I will open the court.
Yes, you may.
Okay, so order. Oyez, oyez, oyez. Anyone having business before the Justice of the Superior Court of Justice, please draw near and you shall be heard. Thank you. So, Your Honor, it's over to you to, I call on the, I guess, the first plaintiff.
Yes. Don't have my agenda up, but the first plaintiff is that Ms. Lewis?
Yes, that would be me, Your Honor.
All right. Are you ready with your first witness?
Yes, Your Honor. I will be starting with the opening remarks.
Thank you. Whenever you're ready.
Good morning, Your Honor, and members of the jury. My name is Tish Lewis, and along with my co-counsel, Nicole D'Alessandro, we are here today representing the plaintiff, Bud Light. Her friends and family affectionately call her B. Members of the jury, I'd like you to think about your favorite song. There's something about it, the way it comes together so effortlessly. When you're listening to it, you don't even realize how each instrument was carefully selected and incorporated. And no one would blame you for not recognizing the minutia of the strings, the chords, and the percussion. When something is so seamless, it's easy to take it for granted. Members of the jury and Your Honor, it may not seem so at first glance, but this case can be understood through the structure of an orchestra. Our everyday life and movement in the world is a seamless orchestra with everyone playing a part. Every single day when you leave your house, you get in your car, you load your kids or your things, and you start down the familiar road to your workplace or to your school, what you're doing is taking a leap of faith. You're trusting people you have not even met yet, to play their role in the intricate orchestra of life, to stay on beat, if you will. I don't use this metaphor to downplay or diminish the very real injuries the plaintiff in this case has suffered. Indeed, quite the opposite. B, like all of us, every day played her role in the orchestra of life. Every day, we take for granted that our safety is not just in our hands, and it depends on each person in the orchestra of life playing their role properly. Members of the jury and Your Honor, this case is a clear example of what happens when others around us don't play their roles properly. This case is about B, a trivia lover who goes to Wish You Were Beer Tavern to spend some quality time with her friends and her loving partner. And you'll get a chance to hear from B today. She will tell you about the healthy and active lifestyle she lived prior to this car crash. She will tell you that she was a repeat runner of the Detroit Free Press Marathon. You'll get a chance to hear from her how she made the responsible choice to ask her partner to drive home after she noticed that she was feeling a little buzzed. And you'll hear how, just minutes from arriving home safely, this fun and loving couple, through no fault of their own, are caught in a tragic yet preventable car crash due to the actions of the other defendants here today. Now, members of the jury, I'd like to ask you, imagine you play your role in the orchestra of life and you perform it appropriately. Imagine you stay on beat, only to find out that the others around you have not. Would you not also request that those other people be held liable for their failures? B then is no different. Now let's talk about the events that bring us all here today. I'm going to take a moment to address the defendant, Wish You Were Beer Tavern. B and the defendant, M. Canadian, went to a trivia night at Wish You Were Beer Tavern. The loving couple, who are self-proclaimed history and movie buffs, joined with their friends in their favorite pastime, trivia. Any business selling alcohol to the public has a duty and a responsibility to ensure that patrons are not served excessive amounts of alcohol. This duty was not new to Wish You Were Beer Tavern. Just like every single other tavern in this province, Wish You Were Beer and its staff had to pass Smart Serve certification, which educates them in depth of this very duty. Nevertheless, the tavern decided to host one of their most popular events, a trivia night, which they knew, or at least ought to have known, would draw a crowd, which would then require adequate staffing. However, as you will hear, the tavern was short-staffed. The few waitresses were so busy, they were hardly able to pay any attention to B's group and continued to serve multiple rounds of alcohol to the group, never checking whether someone in the group was intoxicated. The tavern failed to stay on beat. Now I'm going to take a moment to address the defendant, M. Canadian. After B noticed that she was a little too buzzed to drive, she told the defendant, M. Canadian, this, and they offered to drive B home. M. Canadian, feeling fine and having no indication from the tavern staff or others in their group that they were too intoxicated to drive, agreed. M. Canadian drove along Main Street without incident until they reached the intersection with a faulty traffic light and limited construction signs. Now I'm going to take a moment to address the defendant, Destructive Constructive Inc., which I will refer to as DC Inc. from now on. The couple left the tavern and made their way down Main Street while they were singing and enjoying the high of their trivia win. And you're going to hear from M. Canadian, who will say that suddenly, without warning and without any time to react, the two were hit by a semi-truck, seemingly out of nowhere. But here lies DC Inc.'s failure. DC Inc. was contracted by the city of Bedlam to work on the intersection at Main and First Street where the car crash took place. In order to complete construction, DC Inc. put a number of A-frame barricade signs at each corner of the intersection, blocking it off from incoming traffic. In doing this, DC Inc. recognized that an intersection under construction was not safe, and so therefore blocked it off. Once the project was complete, DC Inc. asked for payment from the city of Bedlam. The city, however, failed to respond to DC Inc.'s request for payment. DC Inc., seeking their own profit interests, decided to take a number of the signs that once were barricading the intersection onto their next project because they did not receive payment. But this left only a scarce amount of signs at the intersection of Main and First Street, where the car crash took place. M. Canadian stated that prior to arriving at the intersection that dark night in November, there was no signage indicating that the intersection was under construction. DC Inc. was offbeat as well. Now I'm going to take a moment to address the city of Bedlam, which I will now refer to as the city. So not only did DC Inc. leave the intersection unsafe with the lack of appropriate signage, the intersection traffic lights were not properly synchronized to safely control traffic. What's worse, the city manager of traffic control does not know who's ultimately responsible for doing so. Perhaps, they say, it's the department that deals with construction road contracts. Company records show that there had been a breakdown in the software and that the lights were off by 0.2 seconds. 0.2 seconds was enough time for the car driven by M. Canadian carrying the plaintiff to be given a yellow light, while the car driven by the defendant, W. Skyver, to be given a green, ultimately leading in the tragic car accident that brings us all here today. The city also failed to stay on beat by not knowing which lights in the municipality needed to be properly synchronized. Now let's talk about the car crash that brings us here today. As I mentioned, B was riding in a car driven by their partner, M. Canadian, before they were struck by a semi-truck driven by the defendant, W. Skyver. The intersection was not well lit. It was without appropriate construction signage. It had begun to rain, and it had a faulty traffic light system. But that's not only what happened. On the date of the accident, W. Skyver was bobtailing. Bobtailing means that W. Skyver was driving their semi-truck without the trailer attached, something that is not permitted to be done on Main Street, a residential road, because it makes it difficult to brake. W. Skyver knew they would need to cross Main Street to get home or to wherever they were going. And W. Skyver knew they were not allowed to bobtail on Main Street because Main Street is a residential road. And the city had already demonstrated that it was dangerous to do so. W. Skyver themselves admits they were going, and I quote, dangerously too fast to brake any further, precisely the reason why bobtailing on residential roads is not permitted. W. Skyver crossed the intersection, struck the car carrying B, and pushed it so forcefully, it ended up on the other side of the intersection. As a result of the sheer force of the impact, the airbags deployed, and B hit their head forcefully off of the solid window frame. W. Skyver decided to disregard their role in the orchestra of life and their duty to ensure that others around them are safe when they made a decision to bobtail knowingly to their own benefit. The evidence will show, and you'll hear from B today, what her losses have been. You'll hear how she loved her job, that prior to this accident, she found purpose and joy in working with animals. You'll also hear about the healthy and loving relationship that she enjoyed with the defendant, M. Canadian. However, as a result of the joint and separate actions of each of the defendants here today in this courtroom, B can no longer enjoy the same quality of life. B has been left with a brain injury, a shoulder tear, memory, and cognition problems. As a lover of animals, B worked at the Humane Society training animals. Fighting through pain, B has tried not once, but twice to return to the career that gave her more than just an income. It gave her purpose and meaning in the world. However, despite her earnest attempts, she's ultimately unable to return to work. The crash has left her with behavioral and anxiety problems, as well as extreme anxiety at that. But that's not the only loss that B has suffered. Her once blossoming and healthy partnership with the defendant, M. Canadian, is no longer. The two have not spoken since the car crash. Members of the jury from the outset, B made responsible choices. Noticing that she was a little buzzed, she handed the vehicle over to her capable partner, who, until the moment of this accident, was driving in a safe manner. She could not have known that the traffic light at the intersection and First and Main would have been faulty and unsynchronized. She could not have known that the defendant, DC Inc., would have left the intersection with a scarce amount of appropriate signage. She could not have known that the defendant, W. Skyver, would bobtail on Main Street, even though they're not permitted to do so. Like all of us in her situation, B believed and had faith in the fact that each of the named defendants would accept their role in the elaborate orchestra of life and do so with the utmost care, as she had done for them. While the damages B have suffered are immeasurable, the plaintiff requests an award of $5 million in general and special damages plus costs. The money we are seeking is a symbol of the wrong that has been done here. This will not give B back the job she loved so much. This will not give B back the healthy lifestyle that she enjoyed prior to this car crash. And this will not restore the healthy relationship that B once had with M. Canadian and which she adored. Members of the jury, we ask you to keep in mind that at the end of the day, B accepted her role in the elaborate orchestra of life and performed it with the utmost care. We ask you to find in favor of the plaintiff. Thank you.
Thank you very much, Ms. Lewis. Are we ready with the first witness?
Yes, Your Honor. Hi, I will be presenting the opening statement for the first witness, Molson Canadian.
Yes. Shall we have the witness affirmed?
Sure, yes, certainly.
Justice Carey, we're actually in this format, we're having, all the defendants are actually doing the opening statements at the beginning. So we.
Okay. Thank you. Go ahead.
Thank you. Well, good morning, Justice Carey. And good morning, ladies and gentlemen of the jury. My name is Brittany Lieberman, and I appear alongside my co-counsel, Matthew Galton, on behalf of Molson Canadian. What you will hear in the opening statements of my learned friends and me is not evidence, nor are the closing statements of my co-counsel and our learned friends. His Honor will tell you that he does not determine the facts in this case. You, the jury, are given this responsibility. You decide the evidence. The statements and claims made by my learned friends, my co-counsel, and me are for you, the jury, to give meaning, for you to give merit. Ladies and gentlemen, have you ever been in a situation where you do everything reasonable? You have good-hearted intentions, but it seems the world is working against you? Everyone has one of those days. Days where the circumstances you find yourself in create the perfect storm. Days where no matter what you do, you can't control the outcome. Days in which all of your well-intended and sound actions are no match against a series of misfortunate events. Ladies and gentlemen, the case you will hear today was one of those days for Molson Canadian. It was a day that started out full of promise, but ended with her unconscious in a hospital bed. Today you will hear that there was a trivia night hosted by a tavern which is subject to the duty of care of a commercial host. You will hear that Molson Canadian attended this tavern, along with the plaintiff, to have a fun date night while participating in trivia. You will hear that Molson Canadian, having all of her wits about her at the end of the evening and out of concern for the plaintiff, drove her home when she was feeling unwell. You also will hear of a malfunctioning traffic light system, an idling truck driver jackrabbiting at the intersection, a broken steering wheel, and a darkened construction zone. These are some of the misfortunate events that occurred that night. Now, while all of these individual elements may appear to be inconsequential, when taken together, one after the other, you will see that this is a series of misfortunate events that culminated in injury to the plaintiff and Molson Canadian. You will see that despite Molson Canadian's best efforts and good intentions, she found herself trapped in this series of misfortunate events because there were forces acting against her. Those forces that create those days where no matter how much you do that is reasonable, how much care you take, you are no match for a perfect storm against you. Ladies and gentlemen, this is a case of an innocent date night gone horribly wrong. A case in which Molson Canadian, having remained careful, trying to get her date home safe, was caught in a storm against which she was no match. Today, you will hear a claim that Molson Canadian was intoxicated when she got behind the wheel. However, you should listen carefully to this claim to form your own opinion as to what happened that evening. You may come to a different view, and you, the jury, decide the facts. You will also hear evidence that the Wish You Were Beer Tavern was in control of its patrons and that they monitored their levels of intoxication. There will be evidence that Molson Canadian is known at the Wish You Were Beer Tavern for her trivia expertise. You will hear that her sobriety was acknowledged as she left the tavern and that she got behind the wheel in a sober state of mind. The evidence will show that Molson Canadian, in an effort to help her date get home safely, ended up driving through the eye of the storm, a pair of malfunctioning, out of sync traffic lights, which the city of Bedlam controls. At the end of today, we will ask that you consider the evidence in totality and find that Molson Canadian was not an agent in the offense, but rather a victim to a series of misfortunate events that culminated in the perfect storm crashing into her. Thank you.
Thank you very much, Ms. Lieberman.
Thank you.
Counsel for Wish You Were Beer Tavern, are you ready with your opening?
Yes, Your Honor, we are ready with our opening.
You may.
Good morning. Oh,
Go ahead.
sorry. Go ahead. Well, thank you. Good morning, Your Honor, and members of the jury and counsel. My name is Corridor, spelt Corridore, first initial V. I am here with my co-counsel, Mr. Workington, spelt Warkentin, first initial Z. We represent Lakehead University and we appear on behalf of the defendant, Wish You Were Beer Tavern. Our opening statement today for Wish You Were Beer Tavern has 4 parts. In part 1, we will outline the facts that we expect the members of the jury to hear throughout this trial. In part 2, we will outline the 2 pleadings of Wish You Were Beer Tavern's defense. In part 3, we will outline the 3 issues for the members of the jury to decide today. And finally, in part 4, we will outline the 5 main points of Wish You Were Beer Tavern's defense. We will now move on to part 1 of our opening and provide the facts that we expect you to hear for Wish You Were Beer Tavern's defense. Members of the jury, a hardworking small restaurant owner cannot always predict the actions of his first-time customers. Wish You Were Beer Tavern's decision to serve Molson Canadian alcohol on November 14, 2019, did not cause the incident that has brought us all here. Wish You Were Beer Tavern requests that this action against them be dismissed. Mr. Robert Brown is the owner of Wish You Were Beer Tavern. He is the only witness that will be testifying on their behalf. I anticipate you will hear from Mr. Brown that he has been the owner of Wish You Were Beer Tavern for the past 27 years. He attributes his long-standing ownership of the tavern to a strict management style and passion for customer service. Mr. Brown takes pride in his family-friendly restaurant and enjoys watching his patrons eat and have a good time. You will hear from Mr. Brown that he has reliable staff. One server has worked for him for the past 10 years. I anticipate that you will hear from Mr. Brown that on November 14, 2019, Wish You Were Beer Tavern hosted a family-friendly trivia game night from 6 p.m. to 9 p.m. Mr. Brown advertised the trivia night and hired additional staff to prepare for the event. You will hear from Mr. Brown that the restaurant is divided into 4 zones, with zone 1 being the closest to the stage. Each zone consisted of 6 tables. However, one of Mr. Brown's servers called him that evening and told him she was sick and could not come to work. I anticipate that you will hear from Mr. Brown that no other server was available to cover this shift. So Mr. Brown bussed the tables himself to alleviate the cleanup work for the other servers. As a result of being 1 server short, each server had 8 tables to look after. You will hear from Mr. Brown that his most experienced server had no issues serving zone 1 and announcing the trivia questions. I anticipate you will hear from Molson Canadian that the Slackers Delight team ordered pizza, wings, and beer during their trivia game. Their team was the fastest to respond to questions and answered almost all the questions correctly. Their team, they ended up winning the trivia game at 9 p.m. The Slackers Delight team was seated in zone 1 and was being served by Wish You Were Beer Tavern's most experienced server. You will hear from Mr. Brown that no staff member observed any signs of intoxication from Molson Canadian. I anticipate you will hear from the plaintiff that after the trivia game ended, Molson Canadian offered to drive the plaintiff home for the evening because she did not think that she was intoxicated. You will hear from Molson Canadian that she and the plaintiff left the restaurant in the plaintiff's vehicle. Later that evening, Molson Canadian collided with Wiley Skyver at the intersection of First Street and Main Street. Thank you, members of the jury. We will now move on to part 2 of our opening. Here we will outline the 2 pleadings for Wish You Were Beer Tavern. In this proceeding, Wish You Were Beer Tavern first defends against the plaintiff's claim of breach of duty of care. Second, if the members of the jury find that Wish You Were Beer Tavern did breach their duty of care owed to the plaintiff, and the breach of duty caused the plaintiff's injuries, then Wish You Were Beer Tavern claims that their liability for the plaintiff's injuries should be reduced because of the actions of the other defendants in this trial contributed to their injuries. As we know, the other defendants in this trial are Molson Canadian, Wiley Skyver, Destructive Construction, Inc., and the City of Bedlam. Thank you, members of the jury. We will now move on to part 3 of our opening. Part 3 outlines the 3 issues for the jury to decide today. The first issue for the jury to decide is whether Wish You Were Beer Tavern overserved Molson Canadian. If the answer to this first issue is yes, the second issue for the members of the jury to decide is whether Wish You Were Beer Tavern caused the collision between Molson Canadian and Wiley Skyver. If the members of the jury decide that Wish You Were Beer Tavern is responsible for the plaintiff's injuries, the third and last issue to decide is whether the actions of the other defendants in this trial reduce any responsibility that Wish You Were Beer Tavern may have for the plaintiff's injuries. Thank you. We will now move on to the fourth and last part of our opening. Part 4 outlines the 5 main points of Wish You Were Beer Tavern's defense. First, I anticipate you will hear from Mr. Brown that on the night of November 14, the staff at Wish You Were Beer Tavern did not overserve the plaintiff or Molson Canadian. Second, I anticipate you will hear from Mr. Brown that Molson Canadian was adequately supervised by the staff at Wish You Were Beer Tavern. Third, I anticipate you will hear from Mr. Brown that the staff at Wish You Were Beer Tavern did not believe that Molson Canadian would be driving that evening. Fourth, I anticipate you will hear from Mr. Brown that Wish You Were Beer Tavern adequately supervised and trained its staff in the sale and provision of alcohol. Fifth and last, I anticipate you will hear from Mr. Brown that at all times, Wish You Were Beer Tavern complied with the legal responsibilities of owning and running a bar. Thank you, members of the jury, and Your Honor, that concludes our opening address.
Thank you very much, Ms. Corridor. Is counsel for Destructive Construction, Inc. Ready to open to the jury?
Yes, Your Honor.
Good morning.
Good morning, Your Honor, and good morning, members of the jury. My name is Tony Virgin. Together with my co-counsel, Melissa Hocko, we are lawyers for the defendant, Destructive Construction Incorporated, who I will be calling DCI from now on. From the perspective of DCI, this is a very simple and straightforward case. It is a case about doing one's job. This is very relatable to most. You're hired to do a job and you do it. As you will hear this morning, this is exactly what DCI did. DCI is an experienced construction company. In this case, DCI was hired by the city of Bedlam, one of the other defendants. They were hired to fix sewer pipes at the intersection of Main and First Streets. The city issued a contract to DCI through their construction department. DCI substantially completed the project earlier than scheduled, prior to November the 14th, as the relevant work had been finished. The sewage pipes, the main focus of the work, had been repaired and were ready for use. The contract was substantially complete. DCI fulfilled their contractual obligation of notifying the city that the work was substantially complete. The city paid DCI, which the city was only required to do upon substantial completion of the contract. After substantial completion of the contract, DCI went above and beyond to make the intersection safe for drivers, pedestrians, cyclists, and DCI's road workers. The workers left behind highly visible construction ahead signs, A-frame barriers, and orange barrels at the corners of the intersection. Members of the jury, while listening to the evidence provided to you today, please pay close attention to the evidence you hear and what actually caused the injuries to Be Light. Be Light was the passenger in a car that was hit by a truck while entering an intersection. The truck pushed the car into the construction area where DCI had been working. This occurred at night on November the 14th, 2019. The car belonged to B. Light. However, she was not the driver. Her friend, M. Canadian, had volunteered to drive the car for Miss Light. She had been drinking earlier in the evening. The car was not functioning properly and was subject to an urgent recall regarding the steering wheel that had not been repaired. M. Canadian was a friend of Miss Light's. M. Canadian offered to drive her home from the Wish You Were Beer Tavern, where they had been participating in a trivia night with friends. M. Canadian had also been drinking that night. On the night of the accident, the Wish You Were Beer Tavern was quite busy and were understaffed. The bartender who was working that night did not provide proof of Smart Serve certification to the owner of the tavern. The servers who were working were handling 8 tables each, 2 more than the usual number of tables in a server's section. At the end of their night of drinking, B. Light and M. Canadian left together in Miss Light's car. M. Canadian, the driver. They left the tavern and were traveling eastbound on Main Street toward the intersection with First Street. As they entered the intersection, a truck collided with their car and pushed them across the intersection into the construction area where DCI had been working. W. Skyver was driving the truck that hit them, and W. Skyver was driving the truck without the trailer attached. DCI was not involved in M. Canadian and B. Light's night of drinking at the Wish You Were Beer Tavern. DCI had nothing to do with the bartender who may or may not have been Smart Serve certified working the bar that evening. They were not involved in allowing servers to serve larger sections of tables than usual. DCI had no knowledge of any broken steering wheels, and DCI was not driving the truck that collided with Miss Light's car. Where DCI is involved is related to the road work they were doing at the intersection of First and Main. The city of Bedlam is also responsible for this intersection, as they are for all of their roads. The city must make sure that users of the roads are kept safe. In order to do this, roads must be maintained, as well as accessories on the road, lights, barriers, traffic lanes, and traffic lights. When a contract for road work is issued by the city, it is then the job of the contractor to keep users of the area safe where the work is being done. When the contract is complete, the job of keeping users of the intersection safe transfers back to the city. Later today, you will hear evidence from Ms. Marinelli, the owner of DCI, and she will explain to you how DCI did their job in keeping users of the intersection safe. They blocked off the intersection and set up highly visible detours. They blocked off eastbound traffic on Main Street and northbound traffic on First Street. They marked the area with highly visible orange and black barrels, A-frame barriers, and construction ahead signs. The job that DCI was hired to do required DCI to dig out the northeast corner of the intersection so that they could access the broken sewer pipes. They were then required to replace the pipes and fill the area they had dug out. The contract for this work was issued by the city's construction department. DCI did the work, notified the construction department of substantial completion, and this occurred prior to November the 14th, the night of the accident. A small amount of work remained, topping up the gravel in the area that had been dug out and paving the roadway. DCI was paid as the work was substantially complete. By November the 14th, DCI had not received a response or acknowledgement from the city after notifying them the work was substantially complete. DCI left behind highly visible markers at the intersection, as well as 2 construction ahead signs, A-frame barriers, and the orange barrels at the corners of the intersection. DCI went above and beyond what they were required to do in order to keep people safe. At the end of this trial, we will ask you to find that DCI is not at fault for the injuries suffered by B Light. After a night of drinking, M Canadian and Miss Light were hit by a truck driven by W Skyver while driving through the intersection at Main and First. DCI was not involved in what occurred at the Wish You Were Beer Tavern. Were not involved in Miss Light's and M Canadian's decisions regarding driving Miss Light's car after a night of drinking, and were not involved in the state of W Skyver's truck or their driving habits. DCI simply had a job to do. They were hired by the city to fix sewer pipes at the intersection of First and Main. This is exactly what they did, and they went above and beyond to keep users at the intersection safe. At the end of this trial, we're going to ask that you find that the actions of the other defendants in this case caused the injuries to Miss Light. DCI had no involvement in any of those actions. Thank you very much for your time, Your Honor. Thank you for your time, members of the jury.
Thank you, Mr. Virgin. Counsel for Mr. Skiver, are you ready to open to the jury?
Yes, Your Honor.
Go ahead.
Good morning, Your Honor. My name is Chloe Carr, CHLOE-CARR. Myself and Miss Jessica Stinson, JESSICASTINSON, represent the defendant, Mr. Wiley Skiver. Life is full of surprises. And sometimes, despite our best efforts and making all the right choices, things just don't go as planned, and we end up in a difficult situation. This was the case for Mr. Wiley Skiver on November 14th of 2019. Mr. Skiver finished work and began his journey home. He climbed into his tractor trailer, the vehicle he drives almost every day, and set off on his usual route home. Every choice he made that evening was completely routine and unremarkable. It was a normal day, or so he thought. What Mr. Skiver did not know was that that day would be anything but normal. Instead, despite every normal choice he made, the night would end with an awful car crash. Ladies and gentlemen of the jury, good morning. My name is Chloe Carr. I, together with Ms. Jessica Stinson, represent the defendant, Mr. Wiley Skiver. Today, you will learn more about the unfortunate chain of events which led to the terrible car accident. You will also learn that through no fault of his own, Mr. Skiver became involved in this accident. He was simply in the wrong place at the wrong time. On the night of the accident, the plaintiff, Ms. Bud Light, and defendant, Ms. Molson Canadian, attended Wish You Were Beer Tavern. While there, the pair, with a group of friends, had several alcoholic drinks. As I expect you'll hear today, the bar was both overcrowded and understaffed, so the group ordered from both their server and the bartender. No one could really keep track of how much they had to drink, including themselves. While Ms. Light and Mr. Canadian were ordering rounds of drinks at the tavern and having tequila shots, Mr. Skiver was wrapping up his workday. In his testimony, Mr. Skiver will tell you he's from the city of Bedlam and has been a professional trailer tractor driver for over 15 years. He'll tell you he was very familiar with his tractor. It's the same one he drives every day. Mr. Skiver will also share how he knows the streets of Bedlam very well. He's constantly making deliveries around the city. The intersection of First and Main in particular is especially familiar to him because he lives just down the road. On the night of November 14th, Mr. Skiver had left his trailer at the yard before heading home, driving just the cab of his tractor. Driving a tractor without a trailer attached is commonly called bobtailing. Mr. Skiver will tell you he'd installed front brakes on his tractor so he could safely bobtail, as it can be challenging to do so with just rear brakes. As you'll hear today, bobtailing is only permitted on certain roads. First Street, the street Mr. Skiver was driving on, is a Class 3 road. That's one of the streets that Mr. Skiver is permitted to drive on while bobtailing. As Mr. Skiver approached the intersection, driving southbound, he'll tell you how he slowed down. And then, after seeing the light turn green and seeing that the intersection was clear, Mr. Skiver began to drive forward. Without warning, a small car suddenly appeared in front of Mr. Skiver's tractor, giving him no time to react before the vehicles collided. This car belonged to Ms. Light, who was a passenger, and was driven by Ms. Canadian. The pair had decided to drive home from the bar. Mr. Skiver is certain the light was green, but Ms. Canadian will say her light was still yellow as she entered the intersection. You'll have to decide whose version you believe after hearing the evidence. You'll hear from Mr. Skiver, who will tell us everything he did that night. He was sober, he was alert, the light was green. He was following the rules of the road, and he simply had no time to stop. You'll also hear from Ms. Canadian. I expect she'll tell us she'd been drinking beer and tequila that night. As she and Ms. Light were singing along in the car, she raced towards the intersection, trying to catch the yellow light before it could turn red. Ms. Light will probably tell you much of the same. So you'll have to weigh their testimonies and decide whose recollection of the events you prefer. And we expect the evidence will clearly show that Mr. Skiver did not cause this accident. Members of the jury, we sincerely empathize with Ms. Light, and at the end of the day, you may decide she's entitled to damages. But all we are asking for is you to find that Mr. Skiver was not responsible. It was the choices of others that led this accident to occur. Despite all the choices Mr. Skiver made that night, he found himself in an unfortunate situation beyond his control. Mr. Skiver was caught up in the accident, but he was not the cause. Thank you.
Thank you. Yes, is counsel for the defendant, City of Bedlam, ready to open to the jury?
Yes, Your Honor.
Go ahead.
Good morning, Your Honor, and members of the jury. My name is Hisham Shah, Hishaam, last name Shah, and I'm here today with my co-counsel, Artem Shushko, first name Artem, last name Sushko, and we are from the University of Ottawa, representing the City of Bedlam in this case today. Ms. Bailey Peltier is present on behalf of the city and serves as the manager of the Traffic Control Division. Today, you will hear from Ms. Peltier about how the intersection of Main and First Street, where the accident took place on November 14, 2019, was under the control of destructive construction, and along with it came the responsibility to ensure the safety of those citizens that entered. As such, the accident that happened with B Light stemmed from the poor decisions that were taken by destructive construction. You will hear how they removed their signage in order to be placed at another project. You will hear how the plaintiff was a passenger in a car which suffered from a steering problem while being driven by M. Canadian, whom our friends claim, and I quote, had a sober mind. But Your Honor and members of the jury, M. Canadian had consumed alcohol throughout the evening, including a tequila shot just 15 minutes prior to getting in front of the wheel. M. Canadian had these drinks at Wish You Were Beer Tavern. On that night, the tavern had planned an extravagant trivia night, hoping to generate one of their biggest revenue nights of the year. Yet, the owner could not be bothered to ensure that their bartender had their Smart Serve license. Not to mention, the bar was one server short as well. B Light did not consider whether M. Canadian was impaired and chose to get in the passenger seat. M. Canadian contributed significantly to this circumstance by making their own poor decisions, by drinking and then offering to drive B Light shortly after. Our friends submit that M. Canadian acted as reasonably as possible. You will hear of how M. Canadian acted reasonably, so reasonable that she was so eager to cross the intersection that she was speeding and then chose to dangerously increase her speed in hopes to cross the intersection. As she sped through the intersection, she was then struck by W. Skeever. M. Canadian had been driving 15 minutes after leaving the tavern and having many alcoholic drinks. You will hear from Ms. Peltier about how the traffic lights have what is called an all red interval, which is where all the lights are red for a period of time. The traffic lights were not synchronized by 0.2 seconds, meaning that the time frame where all traffic lights are red was reduced by an insignificant 0.2 seconds. You will hear from Ms. Peltier about how the software of the lights operate and how the code does not change due to randomness, and once coded, remains the same until manually changed. But the city submits the desynchronization could not have prevented the accident from happening, as M. Canadian would have made the same decision to drink and then get behind the wheel, speed, and then accelerate to rush through the intersection when it was not safe to do so. Ms. Peltier will also testify that 0.2 seconds is faster than a blink of an eye. But what did have an impact larger than the minuscule desynchronization of the lights were the decisions made by the other parties. M. Canadian choosing to drink and then proceed to navigate the wheel and make cognitive decisions to speed and accelerate even faster through an intersection at night. B. Light failing to consider whether M. Canadian, whom had just had drinks with them, would have felt a buzz as they did when getting in the passenger seat. W. Skeever bobtailing on a road that does not permit it. Destructive Construction and Wish You Were Beer Tavern both valuing revenue over the safety of their citizens. With Destructive Construction moving to their next project while the current one was incomplete, and Wish You Were Beer Tavern failing to take proper measures to monitor the alcohol levels of their patrons on their busiest night. You will hear how a series of poor decisions made by the other parties resulted in an unavoidable accident, regardless of what actions the city took. The city submits that the contributing choices of each party worked together to cause this accident, and the city did not contribute to the choices that each party made, which resulted in this accident. Your Honor and members of the jury, that concludes my submissions.
Yes, thank you very much, Mr. Shaw.
Your Honor,
Yes.
we're actually ahead of schedule. Sorry, I'll turn my camera on here.
Yes, quite ahead.
We're ahead of schedule by about 10 or 15 minutes. I suggest if it's okay with you, if you would like to take a break at this time,
Yes.
We would still stay on course if we came back in about 10 minutes or so.
Members of the jury, would you like a break now? I see a lot of nods. Yes. There'll be refreshments for you in the jury room.
Okay, so Your Honor.
Thank you. What time?
10:50, Your Honor, 10:50?
10:50, 5:00.
Yes, 10:50.
And I have 10:33 on my clock.
Oh, okay, sorry.
I'm just going from the
Oh,
computer.
I have 10:33 as well. So
Yeah.
why don't we say 10:45 if that's okay with you?
All right. Thank you.
Thank you.
Mike, you'll be assigning breakout rooms?
I believe Sean is, and I'll just ask the jury members when we come back after the break, if only the jury members can leave their cameras on so that the participants and the observers can see them. Because right now when our cameras are off, obviously they can't see the reactions of the jury.
And breakout rooms are open. So if you want to self-select into rooms, if you'd like, or you can remain in the main room.
Thanks, Sean. Hello, Your Honor. I have one more minute, I think, before we get started. I have 10:44.
All right.
And then we'll be calling the plaintiff followed by a cross-examination like the normal course.
All right. All according to the agenda.
Yep. Okay, order. I have 10:45. Court is now back in session. Your Honor, I'll turn it over to you to ask the plaintiff to call their witness.
Yes, is the plaintiff counsel prepared with their first witness, which I understand will be the plaintiff?
Yes, Your Honor.
Can we have the witness sworn? Witness is sworn.
Yeah, Your Honor, we'll just take notice that all witnesses that appear today are sworn or affirmed.
All right. Yes, counsel, you may begin.
Good morning, everyone. My name is Nicole D'Alessandro, counsel for the plaintiff, representing Windsor Law. Your Honor, I appreciate that you can see my name on the screen, but would it help the court if I spell it?
That's not necessary, but thank you.
Thank you, Your Honor. Hello, Ms. Light. I know we know each other well, but before we begin, I have some formalities to check off for court today. Can you confirm that you are alone in your room?
I am, yes.
And can you confirm that you don't have any notes in front of you?
I confirm, yes. No notes.
And for the record, can you please state your full name and spell it?
My name is Bud Light, Budlite.
As you know, we're here today to talk about the car crash, which took place on November 14, 2019, at the intersection of Main Street and First Street. I'll be asking you some questions, Please let me know if you'd like me to clarify or repeat anything. Do you understand?
Yes.
We'll start off nice and easy to get you comfortable testifying. So to start, how are you feeling?
I'm nervous, really nervous.
It's okay to be nervous. We'll take it nice and slow.
Okay.
How old are you?
I will be 45 years old in April.
Can you tell us a little bit about what you did for work before the car crash?
Yes, absolutely. Well, I used to work at the Humane Society. I taught training officers how to deal with things like dog attacks, raccoon, coyote aggression, as well as the containment of wild animals. It was a physical job, but I liked it because it helps people feel safer when dealing with animals. I had to lift animals as part of the training, but now I can no longer do that. I've always had a love for animals since I was a teenager. I couldn't see myself doing anything else. And I wanted to work there for as long as I could. I tried to go back to work twice, but I can't work anymore.
And what was your salary in this job?
Before taxes, I believe I made around $80,000 a year.
And can you describe yourself before the car crash?
Well, I was extremely active. I ran almost every day before work. I actually participated in the Detroit Free Press Marathon every year. I also played a lot of sports with friends, but overall, I mean, I'd say I was a very calm, happy, joyful person. I enjoyed going out with friends very often. I would often go running with my dog, Rufio. I actually recently had to give him up to a friend after the car crash because I can barely take care of myself now.
We'll switch gears now to talk about the day of trivia at the tavern and the car crash.
Okay.
How many times have you been to Wish You Were Beer Tavern before?
It was my first time participating in a trivia in that tavern specifically, but I've been to the tavern before. It's the closest bar to my place.
And what time did you arrive at Wish You Were Beer Tavern?
It was after work, so I think around 6 p.m. I went there straight to the tavern.
And how did you arrive at the bar?
I drove myself in my car.
Can you tell me about the car you drove to the tavern?
Yeah, it was a green Ford F-150 pickup truck. It works fine, but the steering wheel can be a little stiff at times. I actually never had a problem with it, or else I would have taken it in to get it fixed right away.
Can you describe the evening at the tavern?
Yes, well, I got to the tavern and I met a few friends there at the bar. There were 8 of us in total, and Molson was there as well. It was fun. We're all huge history buffs and we won, so we were all celebrating. We were there for a few hours. I actually had a few drinks, maybe about 5 or 6 glasses of beer. I told Molson that I felt a bit buzzed and she had offered to drive me home. And she decided to drive my car because she had come with another friend. It was nighttime when we left.
And what was your relationship with Canadian?
Well, we met through mutual friends. Things were getting quite serious between us before the car crash, but we didn't speak after that day. I blamed her a lot after the accident.
And what did Canadian have during trivia?
Oh, I'm not sure. I was too focused on the trivia game, but I trusted her to drive my car. I felt comfortable and she felt comfortable. We would always drive home together.
What happened after you left the bar?
Well, I remember Molson got into the driver's seat and I got into the passenger seat. I put my seatbelt on, as I always do. We turned the radio on and we were singing along to the music. My heart was feeling good. and I didn't have any concerns about Molson's driving. It was dark outside, so I couldn't see much.
And how long did it take to go from the tavern to the intersection of Main Street and First Street?
I think just a few minutes.
What's the last thing you remember from that night?
I remember we were driving straight on Main Street, and suddenly we were hit from the side, and the car swerved to the right and it began to roll. My seatbelt held me in my seat, but I remember hitting my head on the side of the window frame. The airbags came out really fast, and at first I was in shock. I saw some powder and I thought the car was on fire, and I started to panic. I was so scared, and I still get nightmares about it, and I can't drive anymore. Sorry, I just need a moment.
That's okay.
Take as much time as you need.
Thank you, Your Honor.
Are you ready?
Yes, yes.
What happened after the airbags came out?
Somebody yelled that they had called 911 and they told me not to move. It felt like hours before a firefighter came and asked me if I could crawl out of the window of the car. The last thing I remember is just waking up in the hospital and the nurses coming into my room.
Now, I want to talk about how this car crash has impacted you. Can you describe your health after the car crash?
Oh gosh, where do I even start? Well, for one, I get headaches a lot. I have major vertigo, which makes it worse. The whole right side of my body hurts, and I'm right-handed, so I can't lift my arm because my right shoulder, is in so much pain. I'm wearing a sling right now. There's radiating pain all down my right arm. My neck constantly hurts to the point where I can hardly move my head from side to side most days. I'm actually wearing this scarf because of the burn marks from my seatbelt. Before the crash, I used to be so sharp, and now I have such a hard time focusing or remembering things. Honestly, I'm just mentally drained.
And what's your memory loss like for you?
Well, I remember a lot of things before the accident, but it's really my short-term memory that's bad. I forget things from one day to another.
Has your financial situation changed after the car crash?
Yes, big time. I'm on disability benefits now. I went from obtaining a salary of $80,000 to $24,000 a year. And most of my income goes towards my rent. So it's been extremely difficult.
And what's your daily routine like after the accident?
Well, my doctors often make me a list of the medications that I'm required to take, and a list to do, basic necessities like shower, brush my teeth, or I'll simply just forget. I see them about twice a month. I also don't drive anymore, so if I need groceries, I'll either take a cab or an Uber, but as you know, that gets quite expensive. I just spend most of my time at home now. I don't have any friends over, and that's mostly because I'm scared I'm going to snap at one of them. I also go to therapy about twice a week to talk about my depression and anxiety.
And how do you feel about your future?
Terrible. My doctors have told me that this is probably the best that I'm going to get, and I don't see my future being the same. I'm now a person with a disability, and an invisible disability.
Those are all my questions. Thank you, Ms. Light. I know this was difficult for you to discuss.
Thank you.
Yes, just to remain in the witness box, we have cross-examination by counsel for the defendant's giver.
Thank you, Your Honor. Good afternoon, Ms. Light.
Good afternoon.
Let's just get right into it. So it was your vehicle that Miss Canadian was driving when the accident occurred?
Yes, that's correct.
You had driven yourself to the bar that night?
Yes.
Miss Canadian had gotten a ride with a friend.
Yes, that's correct.
So Miss Canadian offered to drive you both home at the end of the night.
Yes, she did.
You had an appointment to bring your car in earlier that day
I did, yes.
because it was subject to a recall.
I believe it was, but there was no urgent recall or else I would have taken it in right away.
Miss Canadian, do you recall before trial attending an examination for discovery?
I have, yes.
And in that examination, you swore an oath to tell the truth?
Yes,
Now, you've just told me that it was not an urgent recall, correct?
that's correct, yes.
However, at paragraph 4, lines 5 to 6 of your discovery evidence, or sorry, apologies. That would have been at paragraph 4, line 1, you state, I forgot to tell Canadian that my car was subject to an urgent recall. Did you give that evidence?
I did, yes.
So it was an urgent recall.
Well, I mean, if it was an urgent recall, then they would have asked me to bring the car in immediately. Is that correct?
Well, you had an appointment that day that you missed, correct?
Yes, I did, but it wasn't impacting, my ability to drive. I didn't feel that my car had any issues.
So a mechanic had not looked at your car to confirm it was safe to drive?
No.
You were having a pretty good time at the tavern that night.
That's correct, yes.
You and your friends were playing trivia, enjoying some food and drinks.
Yes,
You were all drinking beer.
yes,
And your team actually won trivia.
we did, yes.
So you were all excited and you celebrated your win a bit.
Yes,
And to celebrate, Miss Canadian bought your group a round of tequila shots.
yes, that's correct.
And you had a tequila shot.
I believe I did, yes.
Miss Canadian also had a tequila shot.
I don't remember. I
These-
didn't keep track of how much she had drank.
These tequila shots were taken about 15 minutes before you left the bar.
I'm not sure. I can't recall that.
After the accident, you were conscious.
That's correct, yes.
And a firefighter had asked you to crawl out of your car through the window.
Yes,
The car had rolled into a construction pit,
yes,
and there was an A-frame barrier under the car.
yes, that's correct.
Now, you were in the passenger seat, like you mentioned earlier.
Yes,
You and your partner, you're enjoying the end of your date, and you're kind of still happy about your trivia win.
I mean, after the accident, I wouldn't say that I was happy at all. I was in a lot of pain. I was in shock. I was scared.
Before the accident occurred, you're driving, you're singing along to the radio, enjoying yourself.
Yes, prior to the accident, yes.
And Ms. Canadian was singing along too.
Yes,
And right before the accident occurred, you were looking at Ms. Canadian.
yes.
As a passenger, you weren't really watching the road closely.
I wasn't, but it was also extremely dark, so there was nothing that I could see outside.
So you can't know for sure if she was driving within the lines of her lane.
I believe she was. I mean, it was a straight road.
You didn't keep your eyes on the road the whole time, did you?
I did not know.
So you can't say with certainty because you weren't looking the whole time.
That's correct, yes.
In addition to the tequila, you also had at least 5 or 6 glasses of beer.
Yes, relatively, yes.
Ms. Canadian had been drinking beer that night too.
Yes, but again, I don't know how many drinks she had had.
Your group had been ordering pitchers of beer from the server and the bartender that night.
Yes, correct.
And you're taking turns ordering the pitchers over the 3 hours you were there.
Yes,
Your group ordered at least 2 or 3 pitchers from the bartender
yes,
and at least a few more from your server.
that's correct. Yes,
You had also got pizza and wings for the table.
yes.
Ms. Canadian didn't eat anything.
I'm not sure.
You didn't see Ms. Canadian eat anything.
I don't think so, no.
Like you mentioned, you were feeling a bit buzzed when you left the bar.
A little bit buzzed, yes, but you know, it was only a little bit and I was still in my right mind to know that I shouldn't be driving.
So by buzzed, you mean a little drunk.
I wouldn't say drunk, no.
Buzzed enough that you didn't feel comfortable driving.
Yes,
And as you were leaving, you told Ms. Canadian this, that you were feeling buzzed.
yes, that's correct.
And so she offered to drive you home.
Yes,
Now, after the accident, you were told Ms. Canadian failed a sobriety test.
yes.
When you agreed to let Ms. Canadian drive you home, you didn't consider whether she might be intoxicated.
I mean, I thought that she wasn't.
She had been drinking with you all night.
Again, I'm not sure how many glasses of beer or alcohol she had, and I thought that, you know, she was responsible to know that she could drive my vehicle.
But you didn't ask her that. You didn't ask her if she was intoxicated.
I did not know.
No further questions. Thank you.
Thank you. Any reexamination?
Yes, Your Honor.
Go ahead.
Oh, apologies, Your Honor. I thought you were calling for the direct examination of Molson Canadian.
No, it's redirect.
I apologize.
Sorry. That's great. That's okay. I perhaps wasn't clear enough. Yes, is there any redirect of the plaintiff?
No, Your Honor, no redirect.
Thank you. And now it's, now you're up for the defendant, Ms. Canadian, or Molson Canadian.
Hello, Ms. Canadian. May I refer to you as Molson?
Yes, you may.
I want to ask you a few questions about your background. So Molson, you're 40 years old.
I am.
You're unmarried.
I am.
You have no children.
I don't know.
And Molson, you're a kindergarten teacher.
I am.
And you've been a kindergarten teacher for 15 years.
I have been, yes.
You've received multiple teaching awards for your prowess.
I have.
And you've received the most conscientious teaching award 3 years in a row now.
Yes, I have.
I want to talk to you about your relationship to the plaintiff. How did you meet Bud Light?
We actually met on a dating app.
And what was your first date with them?
Our first date was November 14th, 2019.
Was this your first time meeting them in person?
It was, yes. We had FaceTimed and texted in the past, but it was our first time meeting in person at the tavern.
How did you feel about going on this date?
I was excited. I obviously haven't been too successful in the dating game so far. I've been focusing on my career, but from our conversations, I could tell that we might be a good match. So I was very excited.
Why did you choose the tavern as your first date spot?
I mean, it's my favorite bar. I go there all the time for trivia night, and I thought it would be an easy way to get to know someone in a fun and chill environment. So I invited B to come along.
Let's talk a little bit about your relationship with the tavern. So how long have you been going to the tavern for?
I've been going with my team Slackers Delight for about 5 years now. They host annual trivia nights.
And how often do you and your team go to this bar on any given week?
We meet the trivia nights are on Thursdays, and we meet about once a week, so Thursdays.
How seriously do you take trivia night?
I take trivia very seriously. I really do love to win.
And how close are you with the staff at the tavern?
We're pretty close since we've been going there a long time. We're on a first name basis, and they know our team pretty well.
So let's talk a little bit about the service and diligence of the tavern at the night of your date on November 14th. So how was the service at the tavern that night?
Well, obviously it was really busy, so it was a bit slow, but they were friendly and attentive to my team like usual. They were the best. Yeah, it was pretty good.
And what is the usual interaction that you have with the wait staff as you normally leave the tavern on trivia nights?
Well, they always see if we're okay to get home. They ask us if we have a ride or if we're safe, and then we say our goodbyes and we're on our way.
And what, if anything, did the waiters say to you and the plaintiff while you were leaving the night of your date?
My waitress asked if we were good to get home, and I said yes, and we were on our way.
And how are you feeling when you left the bar?
I was feeling really good.
And what made you feel good?
Well, we'd won, obviously, and like I said, I'm pretty competitive. I like to win, but I also felt like the first date with Belite went like really well, and I thought there was a really good potential for there to be a second one.
I want to talk a little bit now about the transportation the night of your date. So how did you get to the tavern that night?
I carpooled with a bunch of my trivia friends. We have like a rotating carpool we do.
How did Bud Light get to the tavern?
She drove herself.
Why didn't you guys go together?
I took it as kind of like a first date insurance, you know, if something goes wrong, you want an out, and I totally understood completely.
What were you drinking?
I had beers and tequila.
How many beers?
I had 2 beers over the course of the night.
How many shots?
I had 1 shot after we'd won.
How many rounds of tequila shots did you purchase for your team?
I only bought 1 round of shots, and it was after we had won.
And how long were you at the bar for?
We were at the bar from 6 to 9, so over 3 hours.
How many drinks did Bud Light have?
I honestly can't say for sure. Definitely more than me. A few beers, a few shots.
Why didn't you drink as much as your date?
Well, like I said, I like to win and I like to be sharp for trivia. That's the reason why I go to the bar. And I also know that trivia is on Thursdays, and I have to be up at 8 a.m. to welcome the kiddos to school. So I don't typically drink a lot on weeknights, no.
What did you eat at the tavern that night?
I hadn't eaten anything because I had had a late lunch.
And what did you have for lunch?
At around 3:45, I was driving home and I got a Big Mac meal from McDonald's.
How was it?
It was really good. Thanks. Yeah.
All right, I want to talk a little bit now and direct your attention to what happened right after you left the bar. So what happened to you after you left the bar that night?
Well, as we were leaving, B told me that she wasn't feeling well enough to drive. She said she was feeling a bit tipsy. So I offered to drive her home in her car.
And then what happened?
So I offered to drive her home, and I figured I could Uber myself back from her house, and I thought it would save her the hassle the next day.
Whose car did you go home in?
Bud Lights.
And why didn't you just Uber her home?
Well, like I said before, I figured that I would save her the hassle of having to go get her car in the morning, and I just thought it would be easier on everyone.
And how familiar are you with Bud Light's car?
I haven't driven it before.
Where did Bud Light live?
She lived in town. I don't remember the exact address, but she put it in her car's GPS system, and that's what I was following on the way home.
And how often have you traveled that route?
Since I've lived in town for a while, I do know some of the roads, but I've never traveled that specific route. I was just following the GPS.
I want to ask you a little bit about the events which occurred right before the accident. So up until then, how was the drive?
It was good. We said we were singing along to the music. We were getting to know each other in more of a quiet and chill environment, and I was feeling really good.
And what, if anything, did you notice about the plaintiff's car?
Nothing too bad. The steering wheel was a bit stiff, but I knew every car drove differently, so I wasn't too concerned.
Why didn't you ask Bud Light about mechanical issues with their car before driving it?
Well, I don't typically ask most of my friends about the mechanical issues with their cars. If they're letting me drive, I assume that it's good. And I know that every car feels different, so I wasn't concerned.
And as you approached the intersection of Main Street and First, did you notice the construction?
No, I didn't notice any construction. There were no pylons or signage leading up, so I was proceeding as normal.
What color was the light when you entered the intersection?
It was yellow.
Why didn't you stop?
Well, I knew I had passed the point of no return, and it would be way more dangerous to slam on my brakes right in front of the red light, right in front of the yellow light. And yeah, so I thought it would be better to proceed with caution.
What was your speed?
I wasn't going more than 10 kilometers over.
What did you see as you first entered the intersection?
Well, I looked to my left, right, like left, straight, right, and I noticed on my left side there was a car approaching at a reasonable speed. It was a tractor, I believe, and but it wasn't going. Looked like it was stopping, so I continued to proceed ahead.
Then what happened?
Well, as I entered the intersection, it was free and clear, and I just proceeded through. I didn't see anything.
What happened to you next?
Well, I heard a large vehicle, gearing down on its engine, and I smelled burning rubber. And then all I remember was the impact.
Just take your time. If you need a moment, just do you have a glass? Do you have something? Do you have glass water there?
Yeah. Thank you.
Are you okay to proceed, Ms. Canadian?
I am.
What happened to you after the impact?
Well, my next memory was a wall just coming in on my left side, a white wall, and then all I remember is waking up in the hospital.
And what happened to you at the hospital?
I was taken care of. They ran tests on me, took blood samples, and thankfully I was alive and I only had minor injuries, but they still do affect me to this day.
What, if any, interactions did you have with the police after the accident?
Nothing outside of my statement. They did their usual tests and I was never charged with anything criminally.
Were you intoxicated that evening?
Not even close.
That is all my questions. Thank you, Ms. Canadian.
Yes, just remain there for cross-examination.
May I proceed, Your Honor?
Yes, you may. Thank you.
Hello, Mohsen.
Hi.
My name is Tish. You may have heard me address this court at the beginning of the trial. And as you may know, I'm appearing on behalf of the plaintiff in this case, B.
Yeah.
I'm going to ask you a few questions, and what's really important is that you try your best to answer the questions with a yes or a no. If you feel like for whatever reason you can't and you need me to rephrase, just let me know and I'd be happy to do so, okay?
Thank you, yes.
Great, you're off to a great start then. You hold a valid driver's license to operate a motor vehicle, correct?
I do, yes.
And so you pass the appropriate competency tests to get your license then, correct?
I did, yes.
And so then you would consider yourself a competent driver, right?
I do. I am a competent driver.
B Light informed you at the end of the night that she had a bit of a buzz. Is that correct?
She did, yes.
And you offered to drive B home.
I did.
And you offered because you felt like you were in a better position to drive than B was, right?
Yes, I knew I wasn't intoxicated and I knew I could get us home safely.
So you felt okay to drive then, right?
I did.
Okay. And so you would agree with me that at some point during the night, you and your group were taking shots of tequila, right?
Yes, I had one shot of tequila.
And you
but
had
my
also
group had more.
in your group. Okay. And you had also drinking some beer, right?
Yes, 2 glasses.
Okay. But you were never cut off by the tavern staff. Is that correct?
I was cut off. No,
And no one in your group cut you off either, right?
no, no one did.
And so you would agree with me that your perceived lack of intoxication was informed, at least in part, by the fact that the tavern staff never cut you off, nor did anyone in your group. Is that right?
I know myself and I know my body, so that was where I got that from. And obviously, if someone had told me I wasn't okay, then I would have followed that. But I know myself.
Okay. And so, as you mentioned, you're a competent driver. And so if, in theory, a member of the tavern staff or B or a friend in the group had told you that you were intoxicated, you would have taken that as a sign that you were intoxicated, right?
Yes.
And nobody did that though, correct?
Nobody did, no.
And so we heard from B earlier that the two of you were singing on the way home and enjoying the sort of high of a trivia win. Is that right?
We were, yes.
Okay. And the road you were driving on was straight, right?
It was.
And prior to arriving at the intersection, there was no need to turn left or right, correct?
No, yes, you're correct.
And you never told B that you were having an issue with the steering wheel, correct?
I never did, no. And I wasn't having an issue personally. It felt stiff, but that's all.
Okay, so I'm going to suggest then that the steering wheel was a non-factor in your driving.
Yes.
Okay. You know what an A-frame sign is that blocks a roadway from access, correct?
I do.
Okay. And you didn't see any signage warning you that the intersection was about to be blocked off?
None at all, no. Not even leading up on the road to the intersection.
Okay. And it's true then, as a competent driver, as we've established here that you are today, if you had seen such signs, you would have driven more cautiously. Is that right?
Of course, yes. And I would have been ready and waiting for in case something were to change with the roadway.
You would have even maybe slowed down as you approached a construction site.
Of course, that's the law.
Right? But you didn't see any such signs.
No, I did not.
So you proceeded normally.
I did.
And the intersection, it was not well lit, correct?
It was not.
And you'd agree with me that a dark intersection could be dangerous?
I would say so, yes.
And so you would agree that this intersection was dark, it had rained, and it was not blocked off prior to reaching the intersection, correct?
Correct.
Yeah. And you mentioned that the accident had been suddenly. Is that right?
Yes, I did.
You had no time to react, correct?
None at all, no.
You didn't see W. Skyber coming, did you?
Like I said in my previous testimony, I did see a tractor traveling a safe distance away on my left side, but no, I didn't see him enter the intersection at all.
You didn't see him coming for your car, is what I mean.
No, I didn't.
And so you mentioned you began to see a white screen.
Yes.
Kind of hit you out of nowhere.
Yes.
Thank you, Wilson. Those are all the questions that I have for you today.
Thank you.
Thank you.
Yes, any redirect examination? Counsel?
No, Your Honor.
Thank you. You may step down.
Thank you, Your Honor.
Yes. We will now call on the defendant, wish you were beer for their evidence.
Thank you very much, Your Honor. Today we'll be calling Mr. Brown, the owner of Wish You Were Beer Tavern.
Yes.
There he is. Hello, Mr. Brown. Again, for the record, my name is Zach Workington, representing Lakehead University, and we are representing, again, Wish You Were Beer Tavern today. So, Mr. Brown, Today, I'll be asking you a series of questions. If you don't understand or hear any of my questions, please tell me to rephrase, and I'll do so. So, Mr. Brown, how old are you?
I am 56 years old.
And what do you do for a living?
I own a restaurant, the Wishy Beer Tavern.
All right, Mr. Brown. Now that we all know who you are, I'd like to start by asking you some questions about your business.
Sure.
Can you describe to me the physical layout of your business?
Yeah, my tavern is about a 20,000 square foot building that has my bar along the left side with my booths and tables on the right. The washrooms and the kitchen are in the rear of the business.
Okay, and can you tell me about how your business runs?
Yeah, of course. So my dining area is made up of 4 separate zones that each has 1 server assigned to each zone. Each zone has approximately 6 tables. If there's any issues within the zone in particular, the staff knows that they can come and talk to me about those concerns.
What do you do during business hours?
Honestly, it depends on the night. I'm a small business owner. I have to be flexible with the demands of my business. I wear many hats. I'll help out wherever I can. I often find myself clearing tables, serving food, drinks, really anything to support the team.
You mentioned your team. Tell me about them.
Oh God, yeah, my staff are fantastic. Many have been with me for many years, including one of my top performers. She's been with me for over a decade now. I ensure all my staff are knowledgeable about the ins and outs of working within my tavern.
You mentioned the ins and outs. Can you get into that more?
Yeah, so during my hiring process, I ensure that my staff knows what it means to be working with a tavern, specifically what it means to be working at a tavern that serves alcohol to patrons. I prioritize hiring staff with experience safely hiring alcohol. This allows me to conduct reference checks and evaluate their performance in past employment experiences, just to get an idea about their ability to safely serve alcohol to patrons.
What's your knowledge of Smart Serve certificates?
Yeah, so Smart Serve, I understand that it's the government certification that each server must have before anyone starts working. So before I hire any new staff, I always ask for their Smart Serve certificate.
Okay. Now that we know a bit about your business, I'm going to ask you some questions about the night of November 14th, 2019. Sure. Do you remember what you were doing that day?
Yes, that day I was working at my restaurant.
Can you tell me about that day?
Yeah, so that day was really exciting. We were hosting a trivia night. We wanted to draw in a dinner crowd, so we set the trivia to start around 7 and conclude around 9 o'clock.
What was the crowd like in the bar that night?
You know, it was a bit of a mix. It seemed like most people were there to take part in our trivia event.
Okay, and about how many people were there?
Oh God, it was a busy night. I don't know exactly how many people were there. I just remember that I was running around helping clear tables and serve food most of the night.
How was your staff that night?
So that night I was a bit understaffed. Nothing my staff can't handle though. Being understaffed is just part of working within this industry.
Okay, you mentioned you were understaffed. Did you ever try to fill that spot?
Oh, of course. So being understaffed is never ideal, especially on a trivia night. So I did try to make some calls. Unfortunately, no one was available to take open that open spot on short notice.
And do you remember who was working that night?
Yeah, so it was my usual staff that night. I had one of my best servers working too, the one I mentioned earlier, who's been with me for over a decade. She was working the zone that was facing the stage. However, we also had a new bartender working that night.
Can you tell me more about the bartender?
Yeah, so like I said, the trivia night was her very first night working with us. She seemed like she was a great fit. She had plenty of experience working in bars before she came to my tavern. Unfortunately, she left because she wasn't getting as much tips as she's used to. So she left just after 2 weeks, and unfortunately left before I can get a copy of her Smart Serve certificate.
So did you ever see the bartender's Smart Serve certificate?
No, I never received the copy, not before she left at least. From what I learned from our interviews and her past experience, I am confident that she had it. She had a great experience in the past, and this is why I felt so comfortable letting her bartend on such a busy night for me.
Okay. And can you tell me about how you ran the trivia that night?
Yeah, so for sure, we had my best server running the trivia night from the stage that we usually have in the back. We use the stage for live music, but for that night, we used it for a trivia contest.
Okay, and do you remember who in the bar was taking part in the trivia night?
Yeah, I do remember that most Canadian and Bud Light were there. They were in the trivia contest. I believe they went under name Slacker's Delight, something like that. It was something silly. I'm not sure on it.
All right, where were Molson Canadian and Bud Light during the trivia?
They were at the front at the table facing the stage.
And how many people were at the table with Bud Light and Molson Canadian?
Yes, including the plaintiff and most Canadian, there were 8 people at the table.
Can you tell me what you remember about Molson Canadian that night?
Yeah, I remember that most Canadian was at the table drinking beer with their team. I know they ordered food for the table. I can't tell you specifically what they ate or drank, but their table did order beer and food. Other than that, nothing much sticks out.
Do you remember Molson Canadian's demeanor that night?
Again, not really. Other than the team winning winning the trivia night, nothing really sticks out about most Canadians' appearance or anything.
And what about for Bud Light?
Basically the same as most Canadian. They were at the table sharing beer and food with their team. My staff and I did not notice anything about Bud Light or most Canadian that would cause for any concern.
You mentioned cause for concern. What would create a cause for concern?
One of my biggest signs of concern working in my restaurant is signs of intoxication. This would cause concern for me. I've owned this bar for a very long time. I've ran this bar for 27 years. And I worked some nights where people have shown signs of intoxication. When my staff and I see somebody showing these signs, we do take the proper precautions. However, on this night, neither myself or my staff thought Bud Light or most Canadian were showing these signs of intoxication.
You mentioned proper precautions. What would be proper precautions if someone were to be showing signs of intoxication?
Yeah, so again, I've been operating this business for 27 years, and over this time, I've developed a procedure that seems to work really well when dealing with patrons who show signs of intoxication. The first thing is we stop serving that person immediately. The person receives no more alcohol. If a staff member or myself notice somebody in the bar who's showing these signs, we have a code word that we use. We use donut. It's a low-key word and not many people pick up on it. It's just a word to communicate to the staff, to myself, that there's a person potentially showing signs of intoxication. From that point forward, that person is served no more alcohol until myself evaluate that person to ensure that it is safe.
Okay. So after you find that someone may be showing signs of intoxication, what's the next step?
So again, my priority is just making sure this person's taken care of. I firstly have to ask if they need a ride home. We have a local taxi company in town. I have the number memorized, so I'm able to deliver that number effectively. There's also a bus station that's only a block or two away from my establishment that they can use.
All right, let's get back to the trivia nights.
Sure.
That night, who was serving Bud Light and Molson Canadian?
My best server was taking care of their table. It's the same one that's been with me for over a decade.
Do you remember if the table ordered anything?
Yeah, so our records show the table ordered 6 pitchers of beer, some pizza and wings throughout the evening.
And how much beer does a pitcher hold?
A pitcher holds about 3.5 pints of beer.
How do your patrons normally order drinks at your tavern?
So our preference is that they order drinks from their server. However, there are some occasions where they go up to the bar to order their drinks.
Would you ever stop someone from ordering straight from the bar?
No, I don't have too much of a problem with it. The only time I would stop them if I do see these signs of intoxication.
Is it fairly common that people come to the bar and order drinks to their table?
It's not uncommon. Sometimes people do not want to wait for their server and want to order from the bar instead. However, when this does happen, my staff are great at communicating so that everyone has a good idea of what everyone is drinking.
Now, at Molson Canadian's and at Bud Light's table in particular, did you see who was drinking what at the table?
I didn't notice specifically what each person drank, no. I do know that they split the bill.
What else can you tell me about that night?
Honestly, it was an ordinary night. Trivia was over around 9. The tavern was busy, but not out of hand. The crowd seemed to be having a great time.
And did you notice when Bud Light and Molson Canadian left the bar that night?
No, I don't know exactly when they left, but it was shortly after the conclusion of the trivia night.
Thank you, Mr. Brown. No further questions for this witness.
Thank you. Cross-examination by counsel for M. Canadian.
Hi, Your Honor. Yes, thank you. Just give me one moment. Your Honor, may I proceed?
Yes. Go
Thank
ahead.
you. Hello, Mr. Brown.
Hi.
My name is Brittany, again for the record, and I'm going to be starting off with some basic questions today, just about your tavern once again for the record. So you are the owner of Wish You Were Beer Tavern.
That is correct.
And you've been the owner of this tavern for 27 years, that's correct?
Yes, that's correct.
Your tavern is a safe environment for customers.
Absolutely.
Your tavern can provide a safe environment by monitoring guests' alcohol consumption.
That is part of the ways we provide a safe environment.
And one of the ways you might be able to monitor that consumption is by maintaining guest to server employee ratios.
Yeah, that's important.
And you do that at your tavern.
Absolutely.
As you stated in your chief examination, you're familiar with SmartServe.
Yes, I am familiar with it.
You yourself, as the owner of the tavern, are trained in SmartServe.
That's correct.
And all of your tavern servers are trained in SmartServe.
Absolutely.
SmartServe provides that you should not allow already intoxicated people to enter your events. Is that correct?
Yes, that's correct.
And your tavern follows this protocol.
Yes.
SmartServe policy provides that you should maintain adequate guest to server ratios, and your tavern also follows this policy.
Yes, of course.
And you ensure that your servers maintain this policy too.
Yes, they're quite familiar with the policies.
So SmartServe also discourages customers from excessive drinking in the tavern. Is that correct?
Yes.
And you ensure that your staff discourage excessive drinking.
Yes, again, my staff are very knowledgeable about the policy and procedures.
And under no circumstances would you allow servers to overserve someone.
Absolutely not.
And SmartServe also discourages continuing to serve guests that are already intoxicated, right?
That is correct.
And those requirements also forbid allowing guests to drink and drive.
Yeah, I mean, it ensures once they show signs of intoxication, they have a safe ride home. Yeah.
And your servers are trained to help identify when customers might be intoxicated such that they need a safe ride home.
Yes, they're trained to identify signs of intoxication.
And your staff are trained to help find safe ride home should that be needed.
Yes, they're familiar with multiple courses of action to get people home.
And you certainly wouldn't let anyone drive home intoxicated.
Absolutely not.
And Molson Canadian on the night in question did not drive home intoxicated.
And most Canadian did not show signs of intoxication at my establishment.
And you wouldn't allow someone that did show signs of intoxication to drive home.
No, it would not.
SmartServe also requires that your tavern maintain an incident reporting log to detail guest incidents, correct?
That's correct.
And your tavern upholds this requirement.
Absolutely.
And on the night in question, you didn't receive any incident reports, did you?
There is no incident at my tavern.
And certainly you didn't receive an incident report about Molson Canadian.
Absolutely not. No one in their group.
I'm now going to turn your attention to specifically the night of the incident.
Okay.
So the incident took place on trivia night.
Yes.
Is that correct? And the tavern was quite busy.
Yeah.
But the smart serve rules, they still apply to the tavern when it's busy,
At all times, of course.
just like they don't change on trivia night either.
Absolutely.
And even though it was busy, you were still able to maintain that adequate guest to employee ratio.
Yes.
And you yourself were present on trivia night.
Yes, I was.
You were actually cleaning tables that night
Yes, I was all over my restaurant.
because it was so busy that night.
Oh, I'm always all over my restaurant, not just because it was busy.
And that helps ensure both staff performance and customer safety.
Absolutely, yes. That's why I do it.
So you were able to see your servers and their behavior that night.
Yes.
And you could see the guests that night as well.
Yep.
And you could observe then the guests' behavior.
Yes, of course.
And you could monitor the server's behavior.
Yep.
And you could see that the smart serve rules were being followed by your servers.
Yes, I could tell.
And you could see that even though it was busy, the servers were able to monitor the guests.
Yes.
And even though it was busy, the servers should have been able to monitor how much guests drank in particular.
Absolutely.
And even though it was busy, the servers should have been able to identify if guests needed a safe ride home.
Yes.
You chatted that night with guests like usual.
Yeah, as per usual.
You could observe, their balance, their speech, and any other signs and symptoms of intoxication versus sobriety.
Yes, I'm always looking for signs of intoxication.
And did you chat with my client, Molson Canadian?
I don't recall.
Okay, and there were no incident reports about Molson that night.
Again, no incident reports. They were being tended to by my best server, and she indicated no concern with their signs of intoxication.
And like you said, your best server had her eye on Molson Canadian and Molson's team, and there were no signs of intoxication for anyone on that team.
That is correct, yes.
And when you observed Molson's behavior yourself, she showed no signs of intoxication.
Yes, that's correct. No signs of intoxication.
And there were no signs of overservice by your staff that night either.
Nope.
And if you had seen any guests having issues or showing signs of intoxication, you would have stopped servers from providing more alcohol to them.
Absolutely, I would implement my policies and procedures.
And you did not witness any overservice.
No, I did not.
And you certainly didn't see any intoxicated guests get behind the wheel.
Nope.
And if you had, you would have stopped them.
Absolutely.
And you would have helped them find a safe ride home.
Yes.
And again, your tavern follows and is trained in smart serve, and all of the procedures that night complied with the smart serve requirements.
Yes, that's correct.
And you yourself ensure that servers comply with the smart serve requirements.
Yes.
And had your servers observed anything contrary to the smart serve requirements, they would be obliged to report it.
Absolutely. They'd report that to me directly.
And again, there were absolutely no reports that night.
There were no reports made.
And there were certainly no reports made about Molson Canadian.
That's correct. No reports made of Molson Canadian.
Well, thank you so much, Mr. Brown. Those are all the questions I have for today.
Thank you. Is this council, is this a good time to take a lunch break?
Yes, Your Honor, this is a good time to take a lunch break. We are actually ahead of schedule, which is good. I'll propose we come back at 12:30, if that's okay with you, Your Honor.
Yes.
Okay, so for all the participants, instead of 1 o'clock, I know the schedule says 1 o'clock that we'll resume. Instead, we'll resume at 12:30. Okay.
My apologies to interject.
Sorry.
Can we ensure that we have a breakout room, because we didn't get a breakout room the last break?
Sean?
Your Honor, I believe redirect is still available to the Lakehead competitor.
Oh, sorry, I didn't. That was my error. Yes, redirect, if any.
Thank you, Your Honor. I was simply
sorry
interjecting
about that.
no worries. I was simply interjecting to say that we'll waive our opportunity to redirect. Thank you very much, Your Honor.
Thank you.
And I'll put up instructions about accessing the breakout rooms or assign people if they want to message me if they have issues.
Okay, thanks, Sean. See you guys at 12:30.
Court is adjourned till 12:30.
Thank you, Ron. Welcome back, Your Honor.
Thank you.
I have that we're at 12:31, and I think that we have counsel and the witness in the court here. So I'll call the court to order, and
Yes.
we're now back in session.
Yes, can I call on counsel for destructive construction to call their first witness?
Yes, good afternoon, Your Honor. My name is Melissa Hocko. I am counsel for Destructive Constructive, Inc. and representing Queen's University. And our first and only witness will be Ms. Marinelli for Destructive Construction, Inc. Good afternoon, Ms. Marinelli.
Good afternoon.
How are you today?
I'm a little nervous. Never been to courtroom before.
It's okay. I understand that you are the owner of Destructive Construction, Inc. Is that correct?
Yes, that's correct.
May I ask how you chose that name for your company?
We started off in demolition and now we mostly do construction.
I also understand that it's referred to as DCI. Is that correct?
Yes, that's correct.
I'll refer to it as DCI from now on. And I understand that you are nervous appearing in court for the first time, but please feel free to ask me any questions if you need me to rephrase, and I'll just take these questions slowly. What work does DCI do nowadays as a company?
We mostly do construction work for the city of Bedlam.
What was DCI's relationship with the city of Bedlam in the fall of 2019?
We had been hired to do a project on the northeast corner of Main Street and First Street.
What department at the city hired you for this project?
The construction department.
What department at the city did you have the contract with for this project?
The construction department.
And what department did you report to throughout the course of this contract?
The construction department.
I expect you'll hear evidence today from the traffic light department at the city. Did you have any contact with this department in relation to this contract?
No.
What work specifically did DCI, what work specifically was the construction department at the city hiring you to do for the First and Main intersection?
We were hired to replace the sewage pipes in the north on the northeast corner. So we had to dig up the hole, replace the pipes, refill the hole, and then repave.
When was this work scheduled to start?
Mid-September.
When starting your work at First and Main in mid-September, what, if anything, did DCI do in terms of the traffic that would be going through that intersection?
We redirected the eastbound traffic on Main and the northbound traffic on First.
Did DCI use any items to redirect the traffic?
Yes, we had several construction ahead signs in all directions of the intersection.
Why is redirecting traffic necessary?
We wanted to make sure that drivers would be safe, our crew would be safe, and to do that, we decided to try to keep drivers away from the main, from the work site while we were substantially completing it.
What items did you use to control the traffic in that area on First and Main?
We used orange barrels along the perimeter of the work site, and we also used A-frame barriers.
Okay, so you mentioned construction ahead signs earlier as well. Where did you place those?
We placed several in all directions of the intersection.
You mentioned the orange barrels. Where did you place those?
We placed them along the perimeter of the work site.
And you mentioned A-frame barriers. Where did you place those?
Along with the orange barrels along the perimeter.
Could you describe for the jury what exactly A-frame barriers are?
Sure, they're like portable fences. They're not strong, they're not fixed to the ground, but they do warn drivers of the construction work, the boundaries of it. They have an orange reflective paint on them. So if drivers are driving at night, if they have their headlights on, they're clearly visible.
Thank you. Now let's move forward in time and talk a bit about the final steps in this project. What work did you do directly prior to November 14th?
We had finished digging the hole. We had finished replacing the sewage pipes. And by that point, we had finished partially refilling the hole.
Did you at any point contact the city?
Yes, I contacted them a few days before November 14th, but I'd have to check my records for the exact date.
What did you tell the city when you contacted them before November 14th?
I called to let them know that the project was substantially completed.
What did the city say back to you about the project being substantially completed?
Nothing at first. I didn't hear back from them until after the 14th.
Ms. Marinelli, could you please explain to the jury exactly what substantial completion means in the construction business?
Sure. So it's not about the project being completely done. It's more so about the objective of the project being done. So in this case, we were hired to replace the sewage pipes. So when the pipes were replaced, usable, and no longer exposed, then the project was substantially complete.
Why is it important to let the city know that the work had been substantially completed?
So for two reasons. First, it triggers payment of the contract. And second, it changes control of the intersection from us back to the city.
You use the phrase just then, control of the intersection. Could you explain what that means?
Sure. So essentially, when we take on a contract, we take control or responsibility for the intersection. At the point of substantial completion, that responsibility goes back to the city.
And following substantial completion, what work was left for you at the intersection of First and Main?
We just had to finish refilling the hole and paving over it. By that point in time, it was essentially a large pothole.
And why wasn't this work, the refilling or finishing refilling, and repaving considered necessary to hit substantial completion?
Like I said, so the objective had been completed. It was no longer posing a serious danger. The sewage pipes were completely covered. They were no longer exposed. And it was very minimal work that had to be done by that point after.
After you told the city about hitting substantial completion prior to November 14th, what did you do with the traffic control materials that we'd been talking about earlier?
So I needed them for our next project. So we left behind essential signage. We wanted to make sure drivers would still be safe. But we did need some signs for our next project to keep those drivers safe.
Let's go through the different items you mentioned one at a time again. How many, if any, construction signs did you leave behind and where?
We left behind 2 construction ahead signs for the eastbound traffic on Main and the northbound on First, since those would be the drivers heading towards the work site.
How many, if any, orange barrels did you leave behind and where?
We left behind 4 orange barrels, 1 at each corner on the perimeter of the work site.
And how many, if any, A-frame barriers did you leave behind and where?
I can't recall the exact number, but I know for a fact that we did leave some A-frame barriers behind, and we left them along with the orange barrels along the perimeter.
Ms. Marinelli, why did you choose to leave behind traffic control materials when control of the intersection, as you'd stated, had already switched back to the city after reaching substantial completion?
We hadn't heard back from the city. We still wanted to make sure that drivers going through Main and First would be safe. Even though the responsibility had technically transferred back to the city, we still wanted to do our part to make sure that they would be safe.
And why was less signage and traffic materials needed at this point after substantial completion compared to prior, before substantial completion?
So after substantial completion, the danger posed was far less. The depth of the hole was very minimal. It was far shallower than it had been. At that point in time, it looked like a pothole, essentially. And at that point, the crew needed to finish the project was also much smaller. The control signs and the warning signs are obviously there to protect drivers, but they're also there to protect my crew.
Did you believe that the materials you'd left behind would be sufficient to protect drivers?
Yes, I did.
Did you believe that the materials left behind would be sufficient to protect the smaller crew you'd mentioned?
Yes.
Okay, to recap, Ms. Marinelli, before November 14th, you'd substantially completed the work.
Yes.
You'd called the city to tell them so. They hadn't responded. You'd removed some, but not all of the traffic control materials from the intersection. Then, as you're aware from this proceeding, a car collision occurred on the evening of November 14th. So let's discuss what happened next. When did your crew return to the intersection?
November 15th.
What had happened to the traffic control materials that you'd left behind?
They were missing or moved around.
So let's go through them one at a time again. What had happened to the 2 construction head signs you left behind in either direction?
Those were missing, as well as the orange barrels.
The 4 orange barrels you mentioned were missing, you said?
Yes.
The A-frame barriers?
They were moved to the side of the road.
Did you leave behind any workers to guard those materials during the night?
No, we only leave behind workers if we're actually doing work.
Did you ever get those barrels or signs back?
No, I keep a careful log of every material that we leave behind at a work site, particularly when we're leaving them overnight, and they were never returned.
Just a few final questions about the end of the contract, Ms. Marinelli. Did you finish up the last of the roadwork at the site?
Yes, we did.
What, if anything, has the city said about the quality of your work at that intersection?
They haven't mentioned any issues to me.
And did you receive payment?
Yes, we were paid in full.
Thank you.
Thank you.
Yes, cross-examination. Defendant Beer.
Sorry, my laptop is gonna die. Sorry.
Thank you, Your Honor. We are ready to proceed when the witness is ready as well.
Yeah, ready.
You ready? Everyone's ready? You may proceed, counsel.
Thank you very much. Ms. Marinelli, my name is Vanessa Corridor. I'll be asking you a few questions today. Are you doing all right?
I'm all right. How are you?
Okay, I'm doing well, thank you. So I'm going to ask you some questions. Just let me know if you need me to clarify any of these questions, okay? So to begin, let's talk about your construction experience. You've been managing the safety of DCI construction sites for a long time now, is that correct?
Yes.
And you'd say that you have a professional understanding of construction road signs.
Yes.
Your council even says that you go above and beyond to ensure the safety of construction sites. Would you agree?
Yes.
And your workers will not move construction signs unless you tell them to. Is that also correct?
Yes, no, they would never move the signs without orders.
Okay. Thank you, Ms. Marinelli. Let's move on to DCI's contract with the City of Bedlam. So DCI was hired by the city to replace the sewer pipes. Is that correct?
Yes.
The pipes were replaced underneath the intersection of First and Main Street.
Yes.
And you were the only person managing the sewer pipe replacement.
On the construction side, yes.
Okay. And you were on the site at all times.
There may have been times where I had to go somewhere else. I can't say that I was there 24/7, but I was present at the sites.
Okay, and that's fair, but you did observe the daily progress of the construction. Is that right?
Yes, I believe so.
So according to the contract, once the sewer pipes were replaced, DCI would be filling the pit back in with gravel. Is that correct?
Yes.
And then paving over. So the contract is complete once the pit has been paved over.
Fully complete, yes.
Okay. And at that point, the intersection would be safe for users.
Yes, well, the intersection was still safe for users at the point of substantial completion. Like I said, the hole was partially refilled. It mimicked a pothole at that point in time. And the intersection was technically safe for users the entire time. We never closed down the intersection. We just redirected traffic.
So when the plaintiff's vehicle ended up in the pit on November 14, your contract was still not complete.
It had been substantially completed at that point, but we hadn't finished the last minor details.
Okay. So let's talk about substantially complete. So according to the contract, DCI has control over the intersection before construction is substantially complete.
Yes.
And substantially complete means that the work is almost done.
It means that the objective of the contract is done. So in this case, once the sewage pipes were replaced, usable and no longer exposed.
Right. So until the work is almost done, DCI is responsible for the traffic lights and the road signs in the intersection. Is that correct?
We're responsible for the road signs.
Okay, not the traffic lights as well?
No, those aren't part of the contract. We never issued a work order for those.
Okay. And you're not expected to issue a work order for the traffic lights?
Only if we're shutting down the intersection, which we didn't. We didn't make it into a four-way stop. We didn't shut down the intersection in its entirety. We just redirected traffic.
So you didn't feel that it was necessary to order a four-way stop at the intersection?
No, we didn't, and our contract didn't mandate it, so.
Okay. Are you aware that the lights at the intersection were delayed by 0.2 seconds on November 14?
I wasn't aware at that point in time.
But you had been managing the site at all times, or most of the time, that is?
Yes, but we were working on the sewers.
Thank you, Ms. Marinelli.
Thank you.
Let's talk a little bit more about the condition of the construction site on November 14. So you mentioned to us that the pit was dug in the northeast corner of the intersection.
Yes.
The pit blocked the northbound lane of First Street, you mentioned.
It didn't block it. It may have interfered with it a little bit, but it wasn't unusable.
Ms. Marinelli, do you remember doing a direct examination with us
Yes.
And you remember you were under oath at that time?
Mhm.
During the direct examination, you testified that the pit was blocking the northeast corner of the intersection, with the northbound lane being blocked. Is that correct?
Yes, that's correct.
Okay, and traffic could not pass through the northbound lane of the intersection. Is that correct?
Before substantial completion, no.
So before the contract was substantially complete, the northeast corner of the intersection was blocked off. Is that correct?
Yes.
Okay. You also mentioned that the eastbound lane on Main Street was blocked and that you had to divert traffic around that area.
Yes, which we did.
So then if a car is traveling down the eastbound lane of Main Street, would they not go right into the pit?
No, not with the traffic. Not once it was diverted at the point of substantial completion. It was a much smaller work site at that point. Like I said, it was partially refilled and there was just minor things left to be done afterwards.
Okay. Are you aware that the northeast corner consists of the northbound lane of First Street and the westbound lane of Main Street?
Yes.
Okay. The pit was not filled in on November 14, is that correct?
It was partially filled.
Okay. According to the plaintiff's statement of claim, she claims that the pit was 2 meters deep and 3 meters wide by 6 meters long. Do you agree with this?
I can't recall the exact dimensions.
That's certainly not a pothole if those were in fact the dimensions. But sometime before November 14.
Was that a question? Were you putting that fact to the witness? Were you suggesting, you didn't give her a chance to answer that?
I will rephrase my question, Your Honor. Do you believe that a pothole would be 2 meters deep by 3 meters wide and 6 meters long?
No, but I also don't recall the exact dimensions of the hole that we left, but we also left the barricades around it to warn drivers that there was something there. It wasn't nearly what it was before, but we did put up warnings.
Right. So sometime before November 14, you notified the city that the construction would substantially complete.
Yes.
But you didn't hear back from the city at this point.
No, I didn't hear back from them until after the 14th.
And even though you didn't finish filling in the pit and you didn't pave over, you maintain that this is safe for driving still.
It's still safe for driving, and we left behind essential signage to warn drivers that there was still a construction zone.
So if it was safe for driving, why was there a need for signs?
Well, we still had traffic at any point before. It's not that the it's not that the roads were unusable. And it was, like I said, a much smaller work site than what it was before. And we did warn drivers, and warning drivers, it's just something that we have to do. We have to let them know that there is something coming up ahead, regardless of how large or small it is. It's still something that we have to let them know about. It doesn't necessarily dictate, it doesn't mean that the roads are safe, unsafe.
So according to you, then substantially complete means that there's still a hole in the road that still requires signs around it.
Yes, in this project, yes.
So on November 14, your workers removed the signage from around the pit. Is that correct?
We removed some, but we left essential signage.
You had another job that you were starting the next day, which is why you needed to move those signs over. Is that right?
Yes, we needed to make sure that drivers would be safe at our next site as well.
Did you not have enough signs for both jobs?
We have a lot of jobs going on at multiple points. It wasn't, the job in this case did not require
the same level of signage that it had at the very beginning. So by substantial completion, fewer signage was needed. So it was reasonable to take it for our next project as well.
And my last question to you is, are you aware that on the night of November 14, there was no essential signage surrounding the pit?
I know for a fact that I left the signage there. If it was stolen, if it was moved around, there's not much that I can do at that point. People can walk in, I don't know, but the signage was left.
All right. Thank you, Ms. Marinelli. That concludes my questioning.
Thank you.
Thank you, Council, for the defendant. Oh, and sorry, re-examination?
No redirect, Your Honor. Thank you.
Thank you. The next witness is Mr. Skiver. Is counsel ready to begin?
Yes, good afternoon, Your Honor, and members of the jury. My name is Jessica Stinson, and I'm from Osgoode Hall Law School, and I represent the defendant Wiley Skiver. Good afternoon, Mr. Skiver. I'd like to begin by asking you a bit about your background. You work as a tractor trailer driver?
Yes.
And tractor trailers can sometimes be known as semi-trucks.
Yep.
How long have you been a semi-truck driver?
For over 15 years.
And you're currently self-employed?
Yes, and I have been for about 7 years now.
Do you own the semi-truck that you drive?
Yes.
What areas do you deliver to?
I deliver to various companies near the city of Bedlam.
Mr. Skiver, I'd like to turn your attention to the evening of the accident on November the 14th, 2019. Were you working on that day?
Yes.
How long was your shift that day?
12 hours.
And were you feeling tired at the end of working a 12-hour shift?
No, I felt fine. I often work 12-hour shifts, so I'm pretty used to it by now.
What time did you arrive back to the yard that evening?
Around 8 p.m.
Were you unable to unload your trailer in the yard?
No, no one's there to unload it.
What did you do when you realized there was nobody there to unload it?
I parked the trailer in the yard and then bobtailed the truck home.
Can you clarify what you mean by bobtail?
I mean, driving just the front part of the truck on its own without the trailer attached.
Okay, I'd like to talk a little bit more specifically about bobtailing. Does bobtailing affect your ability to operate the semi-truck in any way?
It would affect the braking.
And how does bobtailing affect the braking?
So semi-trucks typically just have rear brakes, which work to slow the trailer down when it's attached. But when you're bobtailing, the rear brakes just bounce along the ground and the truck just tips forward a bit.
Are there any adjustments that can be made to a semi-truck to enable it to bobtail safely?
Yes, you can install front brakes on the truck.
And have front brakes been installed on your truck?
Yes.
Now, even with the front brakes installed, does bobtailing affect your braking?
Yeah, so you have to slow the truck by gearing down first before you can apply the brakes.
Have you bobtailed your semi-truck before?
Oh yeah, very often. You usually bobtail when you're picking up or dropping off a trailer.
Is it safe to bobtail your semi-truck?
Yes, on certain roadways.
Are there any restrictions on bobtailing on the roadways?
Yeah, you cannot do it on the highways or class 2 roadways.
Okay. Returning to the night of the accident, what street is the yard that you were delivering to located on?
On First Street.
And what street is your home located on?
Just down the road on First Street.
Are you familiar with the area then?
Oh yes, very familiar.
What roads were you going to take home on the night of the accident?
First Street.
Were you planning on driving on any other roads on your way home?
No.
And was First Street the street that you were on at the time of the accident?
Yes.
What class of a roadway is First Street?
It's a class 3 roadway.
And is bobtailing permitted on class 3 roads?
Yes.
What direction were you traveling on?
South.
And where did the accident occur exactly?
It occurred at the intersection of First and Main.
What class of a roadway is Main Street?
It's a class 2 roadway.
Mr. Skiver, did you know that you were going to be passing through Main Street on your drive home?
Yes, but I wasn't going to be driving on Main Street itself at all.
Now I'd like to focus a bit more specifically on the moments leading up to the accident. Did you have any alcohol to drink that day before you started to drive home?
No,
Were you eating anything while you were driving?
no,
Were you on your phone as you were driving?
no, it wasn't.
You mentioned that you were driving southbound on First Street. Can you please talk us through your experience of what happened in this accident?
Sure. So I was approaching the intersection at Main and I had a red light, so I started to slow down. Then when I was getting closer to the intersection, my light turned green and the intersection was clear, so I continued into it. And just as I was entering the intersection, all of a sudden this truck appeared in front of me out of nowhere. And I didn't have any time to stop and I ran into the truck. And after I hit the truck, I tried to brake, but because I was bobtailing, I had to gear down to slow my truck first. And so I stopped my truck on first, just past the intersection, and then called 911.
Okay, I'd like to break that down just a little bit further. You mentioned that you were slowing down as you were approaching the red light. Approximately what speed did you slow down to?
To less than 25 kilometers an hour.
And did you apply the brakes as you were approaching the red light?
Yes, I was braking when I saw the light turn green.
Approximately how far back from the intersection were you when you saw the light turn green?
About 2 to 3 car lengths.
You had said that the intersection was clear, so you continued into it. How did you establish that the intersection was clear?
So there were no cars in the intersection at that time, and I looked to my left and right and didn't see any cars coming.
Did you see any car headlights around as you approached the intersection?
No.
Around what time was it at this point?
Around 9:30 p.m.
Was it dark out at that time?
Yes.
And did you have your headlights on your truck?
Yes.
What was the lighting of the intersection like?
It was pretty dark. The intersection was not well lit.
Can you describe the intersection on that night?
So one of the corners of the intersection was torn up a little further down in Miss Canadian's lane, and the torn up area was blocked off by reflective A-frame barriers.
How did you know that the A-frames were reflective?
I had my headlights on because it was dark out and my lights lit up the barriers so I could see they were reflective.
And you said that you were entering the intersection. As you were entering the intersection, the plaintiff's truck appeared in front of you out of nowhere. What did you mean by out of nowhere?
Well, I didn't see it coming up the road when I looked. Like I said, the truck didn't have its headlights on and it was pretty dark out and it was dimly lit. So I didn't see it until it was right in front of me.
Were you surprised when you saw the plaintiff's car?
Yes, like I said, it came out of nowhere. Plus they had the red light and they were heading straight into the construction pit.
How many lanes is Main Street?
It's a 2-lane road, 1 lane going each way.
So at the time that you saw the plaintiff's car, about how far away from it would you have been?
So I was partway through the westbound lane on Main, so I'd say less than a car length away, maybe half a car length.
You said you didn't have time to stop before you struck the plaintiff's truck. Did you swerve out of the way, try to swerve out of the way at all?
No, I didn't have time.
Did the fact that you were bobtailing affect your ability to stop in time before the collision?
No, it wouldn't have mattered. I didn't see him coming until a split second before I hit him. So braking before just wasn't an option. I didn't have time to react before the collision.
Where did the plaintiff's car come to a stop after the collision?
In the construction pit in the southeast lane.
Did you see anything in the construction pit with the plaintiff's car?
Yes, one of the reflective A-frame barriers was stuck under the plaintiff's cars in the pit.
And you mentioned that you had brought your truck to a stop on First Street, just past the intersection, and you called 911. What did you do after that?
I went over and checked on them and I told them to stay in the car until help arrived.
And then what did you do, Mr. Skipper?
I waited there until the ambulance got there to make sure they were going to be okay.
Thank you very much, Mr. Skipper. No further questions.
Thank you. Cross-examination by the city council.
Your Honor, thank you. Mr. Skiver, are you ready?
Yep.
Begin? Okay. Good afternoon, Mr. Skeever. I'm going to ask you a series of questions today. To begin with, you do short haul deliveries for various companies near the city of Bedlam, correct?
Yep.
And you are a self-employed driver?
I am.
Now, Mr. Skeever, just so that I understand and the court understands the process of bobtailing, I'm going to need your help explaining it. To begin with, where are the main brakes located on the tractor?
So there are the front brakes that are installed and just the regular brakes in the car that I can really place specifically.
So there's the main brakes when you're bobtailing, you don't know where they are located?
Not specifically, but I do know approximately where they would be in the car.
Okay, and what do these main brakes serve to do?
They serve to essentially slow the car down when you're not bobtailing, but with the front brakes, it helps when you are bobtailing.
Right, and
Sorry, I
bobtailing,
thought this was sorry for interrupting, but is this a car or a truck?
where
Truck.
it's the witness testified and discovered that it's a car. So I believe it to be a green car. But the witness is driving a truck, a tractor.
All right, so you're asking him about the vehicle that hit him?
No, I'm asking about his tractor and the process of bobtailing.
Right, and he keeps referring to it as a car, or you do.
No.
So I don't know if you've confused the jury, but I was a little confused about with the reference to the car. But we're talking about his truck without a trailer.
Correct.
All right, go ahead.
Right. So just to clarify, bobtailing is when you drive the tractor without the trailer, correct?
Yep.
And when the trailer is removed, what happens to the main brakes when you try to brake?
It takes a while to, so you have to gear down first and then slow down slowly, and it would not stop immediately.
Okay, and you installed front brakes because it can be challenging to brake with just the rear brakes?
When you're bobtailing, yep.
Okay. And when you're bobtailing, like you mentioned, you would first gear down.
Yep.
And then apply the brake slowly.
Yep.
And then you would gear up again to accelerate, correct?
Yep.
Now, Mr. Skeever, you were bobtailing that night when you were driving home, correct?
Yep.
And you also know that bobtailing is not permitted on certain roadways, correct?
Correct.
And Mr. Skeever, you were following the rules of the road, is that right?
Yep.
So you're familiar with First and Main Street because you live down the road, correct?
Yep.
So then you must also be aware that a rule of the road is that bobtailing is not permitted on Main Street.
I am aware of that, but I did not drive directly on Main Street. I simply crossed it, which is allowed.
Right, and you knew you would be crossing Main Street since that's the same route you've been taking for about 15 years, correct?
Yep.
And when you were crossing the intersection, for that moment, you were on Main Street, correct?
Correct, but you usually have to go through some streets like main streets that are not necessarily permitted to go through the other streets, but I was only crossing them, not on them at any time.
Right, so we agree that at the point of you being in the intersection, you were on Main Street.
Sure, yeah.
You also worked a long 12-hour shift that night, correct?
Yeah.
Okay. I want to talk about what took place at the intersection of First and Main Street. You were alert and focused on the traffic lights, correct?
I was alert, yeah.
And as you approached the traffic light, it was red.
Yeah, my traffic light was red, but it turned green as I was approaching.
Right, and as we talked about the process of bobtailing, you then took the steps to gear down.
Yep.
And you slowed.
Yep.
And despite having worked a 12-hour shift, you were so careful that you took the steps of slowing down first and gearing down when the light was red, correct?
Yeah, so since this is a job that I've been doing for quite a long time, and I am used to these 12-hour shifts, and I take all precautions to be alert, even after 12-hour shifts, I was still very precautious when I was looking at the lights.
Okay, and you saw the light turn green then?
As I was entering the intersection.
Right, and then you geared up and accelerated.
I was slowing down as I saw the light turn green, and I barely had time to accelerate before the car came up.
So we agree that once you came to a stop and you saw, or once you were slowing down and gearing down, you saw the light turn green, and then it's reasonable to presume that you would have geared up and proceeded to accelerate, correct? Because it was green for you.
I guess you could assume that, but I was also going uphill and already not going at a very fast speed, so I barely had time to accelerate there.
So you did not accelerate?
I did, but for a split second, then it probably wasn't enough for me to accelerate fast enough while I was going uphill.
So we agree that you, no matter the amount of acceleration, you did gear up and accelerate.
I tried to for a split second.
Okay, and you were 2 to 3 car lengths at that point from the intersection, correct?
Correct.
And the process of gearing up and accelerate, how long would you say that would have taken?
I'd say a few seconds. I'm not quite sure about the exact details, but it also takes a while for the car to stop itself, even after I slam on the brakes.
Now, Mr. Skeever, I want to take a quick moment to discuss driving in general. When you're at a red light, you would look for any pedestrians crossing, correct?
Yep.
And you would also ensure you're parked behind the white line.
Sure.
You might also look at other traffic lights until they turn red, correct?
I guess when I'm looking left and right in my peripheral vision, I can see the traffic lights on the other side, but usually when I see a green on my end, I assume that it's red on the other side.
Right, and when you see this green and you're proceeding through the intersection, you might look both ways, correct?
Yeah.
Now, Mr. Skeever, you saw the intersection was clear, correct?
Yep.
And you would have looked both ways to make that assessment, is that right?
Yep.
Now, it was when you entered the intersection where you struck what you call a truck.
Yep.
So did you strike a truck at that intersection?
I struck a green truck, yeah.
Okay, you do recall that you gave an examination for discovery, correct?
Yep.
And that was the truth then?
Yep.
And you gave an oath for that discovery?
Yep.
So might I refer you to paragraph 4 of that discovery where I quote, "As I crossed the threshold of the intersection, a little green car ran the red light and appeared in front of me." Now, Mr. Skeever, I'm going to ask you again, at that intersection, did you strike a truck?
I think I struck a green car.
Okay. And the light for the car you hit was red, correct?
I think so if I would have seen that the light wasn't red, I think I would have been alerted to it, because usually it's very uncommon for me to have the green and them to not have a red, but I mostly just saw my own light, and I think I saw that the other side was red.
So you did not see the light of the other or the other traffic light?
I'm fairly certain I saw that it was red in my peripheral visions when I was going through it.
Okay. And so that car ran a red light?
I think so.
Okay. You tried to apply your brakes after hitting the car, correct?
Yep.
But to stop, you have to gear down?
Yep.
And then you apply the brakes?
Yes.
And when you struck that vehicle, you were bobtailing, correct?
Yep.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, I think I have a couple of questions, Your Honor, if I may.
Yes.
Mr. Skeever, my friend asked you about your location at the point of the accident, and if you were at Main Street on the point of the accident. Can you describe for us again exactly where you were? Did the accident happen in the intersection?
Yep.
And you were driving southbound on First Street at the time that the accident happened?
I was.
Okay. My friend also asked you about whether you hit a truck or a car, and he referred you to your prior statement that you had made an examination for discovery. When you made that statement in examination for discovery, were you considering the make and model of the vehicle that you hit?
No.
Okay, that's all. Thank you.
Thank you. Is the City of Bedlam ready with their first witness?
Ms. Pelletier, are you ready?
Yes, I am ready.
Yes, Your Honor, we're ready to continue.
Go ahead.
Thank you, Your Honor. My name is Artem Sushko from the University of Ottawa, and I represent the City of Bedlam. Ms. Pelletier, I'm going to ask you a series of questions today. Please answer loud and clear for the court. If there are any technical difficulties, we'll pause and resume after they've been resolved. If I'm unclear at any time, please let me know. Do you understand?
I understand.
I understand you're an engineer for the City of Bedlam, having worked there for over 40 years. When did you start working for the city?
Yeah, so I got my engineering degree in 1975, and then so I started work right after that. So it's been about 46 years now, I'd say.
And you work in the traffic control division?
Yes, I do.
What's your role there?
So I'm the manager of the traffic control division. So like on top of my duties as an engineer, I also supervise 12 employees.
And why do you need a team of 12 employees?
Well, just given the size of the city and the amount of traffic lights, all of which we oversee, 12 employees is about the appropriate amount for the amount of lights we have.
You said you oversee the traffic lights. What does that mean? How are they oversaw?
So we, in the traffic control division, we oversee the software that manages the lights. So we are the ones who like create and run the software.
Okay. And how do changes happen to software?
So software changes through like human intervention. So it changes if we are requested to make a change to the lights, or typically like by a contractor or something like that. But yeah, software, it requires us to intervene and to change it.
And before November 14th, 2019, when was the last time a change was made to this intersection software?
I don't know. It was long enough ago that it's not in our records anymore.
And you understand we're here today because of an accident that occurred on 1st and Main Street on November 14th, 2019, yes?
Yes, I am.
Were there any issues with the traffic lights around this time?
Yeah, so our records show that after the accident, we realized that there was a 0.2 second desynchronization in the lights at 1st and Main Street.
And what led to this realization?
Well, when there is an accident, it triggers a review. And so we reviewed how the lights were operating.
You said it was after the accident. Exactly when did you find out about this glitch?
I don't know exactly, but it was very shortly after the accident, that probably whatever the next working day was.
You mentioned earlier that it was a 0.2 second delay. Can you quantify that? What does that mean?
Yeah, so based on the guidelines from the Ontario Ministry for Transportation, intersections are meant to have what's called an all red interval. And all red intervals typically last about, well, the guideline is that they're meant to last about 1 second. And the slower the speed limit, the more time recommended, just so that there is appropriate clearance. And if the intersection is particularly large, for instance, the guidelines would be that it would be longer than 1 second. Just given typically our standard for the 2-lane roadways is 1.3 seconds. So we have an all red interval of 1.3 seconds. And so when there's a 0.2 second delay, it means that the all red interval is 1.1 second as opposed to 1.3.
And what kind of impact would this difference in delay have on a driver?
They wouldn't notice it. A 0.2 second delay is 0.2 seconds in general is faster than a blink of an eye. It wouldn't be perceivable to a driver.
I want to turn now to the physical state of the intersection of Main and First Street itself. What road runs from east to west?
Main Street runs from east to west.
And so First Street runs from north to south?
Yes.
What's the speed limit in this area?
It's 50 kilometers an hour.
And how would construction impact the speed in this area?
Well, if the construction company submitted to us that they needed to lower the speed limit, then it would be lowered. Otherwise, it would continue as normal.
And we heard from DCI earlier today. I understand that there's some construction going on. Can you explain why?
Yeah, so there was a problem with the sewers near the intersection of First and Main. And so DCI was the company that the city contracted with to make those repairs.
And why did the city not undertake the repairs itself?
I would say it would be pretty unusual for a city to undertake construction work on themselves. It's pretty standard that we would contract with a third party and we'd put out for tender, and the company with the best bid and that had kind of the parameters we're looking for would receive the contract.
So after going through the tender process, what's the typical procedure a contractor like DCI would follow, having received the bid?
So they would submit a work order that would delineate kind of what the project was. It would have things like when the work would be, it would have a timeline. And so it would say things like when the work was expected to be substantially complete. There would also be things in there if they needed changes to the city lights, that would be in there as well.
So what did this particular work order call for?
So this particular work order, it said that the work would be substantially complete on November 16th of 2019. And that's the real, other than like the specifics of how they were going to go about repairing the sewers, that's about it.
I want to take a moment just to follow up on something you said earlier. You said something that could be done in the work order is a change of lights to a four-way red. What happens to the traffic lights if no changes are called for?
Nothing will happen.
So now I want to turn to the repair work itself. I want to understand the process a little bit better. You were talking about substantially complete. What does that mean? What is substantial completion?
Yeah, so it's a way for them to signal to us, for the construction company to signal to us that the main part of the work that they were doing was wrapping up, and primarily it serves in the contract, to inform us, like they had November 16th as the date that it would be substantially complete, and then that triggers payment for them.
And what does the city do to complete the contract on communication of substantial completion?
Yeah, so we would wait for communication from the construction company that the work was substantially complete, because they would want to be paid. And then we would sign a substantial completion certificate, which is pretty standard for city contracts.
And under the contract, who was in control of the intersection before the work was finished?
The construction company.
And who's responsible for safety during the repairs?
Also the construction company.
What safety measures might be in place while the work is underway?
That I wouldn't particularly know. It would be up to the construction company to make those safety adjustments, like cones, barriers, reduced speed limits, whatever they identify as being necessary.
You mentioned earlier that there was the inclusion of a timeline in the work order.
Yes.
How would the city find out about the progress of the work itself?
So it could be through a phone call or an email to the construction department. They would, when the work was substantially complete, they could make a phone call or send an email that the work was substantially complete.
And regarding this last report, how was that communicated in particular?
So we don't have any records, not just, we don't have any records that the construction company communicated with us that the work was substantially complete. We do have record of them contacting us when the work was complete, and then we paid them after that.
Your Honor, that concludes the City of Bedlam's direct examination. Thank you.
Thank you very much. Cross-examination by counsel for destructive.
Thank you, Your Honor. Again, my name is Tony Virgin, representing the defendant, Destructive Construction Incorporated. Good afternoon, Ms. Pelche. You work for the City of Bedlam in the Traffic Division, correct?
Yes.
You're the manager of the Traffic Division?
Yes, I am.
You spoke a great deal about a glitch in the traffic lights. That was at the intersection of Main and First, right?
Yeah, I don't believe I used the word glitch. There was a desynchronization.
Okay, a desynchronization. The desynchronization was caused by a breakdown in software, right?
We don't know what it's caused by. Software doesn't just change. It would have been like that from the last time the software was changed.
Okay, Ms. Pelletier, you were asked questions during an examination for discovery earlier in the proceedings, right?
Yes,
At that time, you swore an oath to tell the truth,
yes, I did.
and you did tell the truth during that examination?
Yes, I did.
In that examination, you mentioned that there was a breakdown in the software. Is that correct?
Perhaps, maybe I said that word.
Okay. Okay, so let me just bring up the discovery evidence that we have for you here. I'm sorry. So we were going to share on the screen, but unfortunately screen sharing has been disabled. So just to kind of expedite this, second to last paragraph of your discovery, it says records show there'd been a breakdown in the software. Lights were not synchronized. So can you confirm that there was a breakdown in the software?
Yeah, I mean, I would use that vernacular just to communicate what a software desynchronization would mean to the general public. So I did use that word there.
Okay, so your department manages this software. There was a breakdown in the software, and you mentioned that it caused there to be a desynchronization of 0.02 seconds, right?
0.2 seconds.
Okay, and this breakdown, you mentioned that it would cause the lights to be out of sync, which would allow drivers to see lights that would permit them to enter the intersection, correct?
No, I didn't say that.
Okay, so I guess I'll rephrase my question then. When you mentioned the lights and the desynchronization and the breakdown, you said that drivers would notice it, but it would be barely noticeable, like the blink of an eye, correct?
I didn't say that they would notice it. I said it would be imperceivable. They wouldn't notice a 0.2 second difference.
Okay, so the desynchronization, you'd agree then that it wouldn't really cause an accident.
It would not cause an accident.
Okay, thank you. You mentioned the contract between DCI and the city of Bedlam. You're aware the contract exists, right?
Yep,
And you work in the traffic control division, right?
I do.
Not the construction department.
I don't, but we work very closely together because we have projects that overlap all the time.
Right, but you don't work in the department for the city that manages contracts between the city and contractors.
Well, that's not entirely correct. Like, we're still responsible for the contract element. Like, we're still in the loop on all of that.
So an element that you would be responsible for then would be the change to the traffic light software, correct?
Not unless the construction company asked for there to be a change.
Is the construction company, in this case, DCI, they're not required to issue a work order changing the traffic lights according to the contract, right?
They are not required. It's not the law.
Right, it's not the law. And you're not aware if it was a term of their contract, right? Because you don't work in that department?
No, I saw the contract. It didn't request for the lights to be turned into a four-way flashing red light because all the contracts are shared with me.
DCI is obligated to provide updates on important developments of the work, one being substantial completion, correct?
Yeah.
And you indicated earlier that the contract was meant to be completed on November the 16th, right?
It was meant to be substantially completed on November the 16th.
And you're not aware that it was in fact completed earlier, right?
I know that it wasn't because we didn't sign on a substantial completion certificate, which is standard across the construction companies, not just in Ontario, but across the country.
Is the traffic control department, am I right in saying that that wouldn't be the department that would actually sign off on a substantial completion certificate?
You wouldn't be incorrect. We would be aware that it was signed though.
DCI had no obligation to make you or your department aware of substantial completion, correct?
My department, no, I would say that you're correct. They would have to let the construction department know.
So you're not aware of when the contract was substantially completed?
I know that it was completed after the date of the accident because when we did pay them, I was in the loop on that.
At the time of the accident, you're not aware the contract was substantially completed.
Well, I know that it wasn't because there was no completion certificate.
Your department wouldn't have been notified, correct?
We would have been notified by the construction department.
Okay, but you wouldn't have been notified by DCI. They had no obligation to do so.
That's
I
correct.
think excuse me, but we're talking about notification of substantial completion.
Yes,
When
Your
you say not notified, okay, thank you.
In order for us to gain evidence as to when the contract was substantially complete, would you agree that it would be better for us to speak with a witness from the construction department?
I mean, I am privy to everything that has to do with what's going on with the construction department because the city is being primarily.
Yes, I'm not. Yeah, so is this an objection or is this a clarification by? Sorry, I can't see who's.
It is an objection. Council is speculating.
Well, it's not part of the. For the purpose of this moot, it's not part of the witnesses. You have to take the witnesses you're given. I think to go behind that and suggest that the party didn't put the right witness into the litigation is not part of the scenario we're dealing with. So I hold the objection.
Thank you, Your Honor. No more questions.
Any redirect?
No, Your Honor. The city of Bedlam rests.
Thank you. Members of the jury, you may need a rest at this point. Is this a convenient time for a break?
Yes, Your Honor. Looks like we have a scheduled 10-minute break. If that pleases the court, we could come back at, I have it's 1:30. So yes. 1:40 we would come back.
Yes, moving right along. Good.
Okay,
10-minute break. Used to be we'd say smoke them if you got them, but you can't do that anymore. All right. Okay, 10 minutes. Thank you.
Hello, Your Honor. Welcome back.
Thank you.
So we'll bring the again. We'll continue with the proceedings. Your Honor, it's the party.
I'm sorry. I have it. We're into closing statements.
Yes, that's correct. I believe
yes.
Western's going first for the defendant, Molson Canadian.
Thank you. Yes, anytime that counsel is ready to start the closing argument to the jury.
Thank you, Your Honor. Good afternoon, Justice. ladies and gentlemen of the jury, if you remember back to the beginning of this trial, my co-counsel, Ms. Lieberman, asked you if you've ever had one of those days. A day where you had the best of intentions, followed all the rules, did everything right, and you acted as any reasonable person would have. But still, everything just seemed to go wrong. A day where all your efforts and intentions were no match for a perfect storm of misfortunate events. Now, I know I've certainly had many. This analogy of the perfect storm that we keep bringing up comes from a true story about a crew of fishermen setting out on the Atlantic Ocean. Now, these fishermen are masters of their craft, and they do everything right in preparing for their fishing journey. They purchase all the best equipment, prepare and plan for any emergency which would come their way. And in their case, they're all very experienced fishermen. This is their profession, and they all know how to do it. However, even though these veteran fishermen had carefully planned and prepared for every emergency, the ship and its crew were no match for the storm of the century. The three largest systems in the Atlantic collided to create a maelstrom of overpowering forces, which one after another overwhelmed the fishermen and defeated them. The weathermen didn't even predict the storm, and then it happened. How could the fishermen have predicted this storm? They were the experts, and there was nothing they could have done to predict it. It was truly the perfect storm that no one could have prepared for. Now, ladies and gentlemen of the jury, you can no more place blame on Molson Canadian as you could the fishermen caught in the perfect storm. We don't think of blaming them, so why would we think to blame Miss Canadian? Just like these fishermen, Miss Canadian did everything reasonable on the night of the accident, but still she was unable to predict and combat the malfunction of the city's unstick construction lights and the dangerous driving of Mr. Skiver. Just like the fishermen, Miss Canadian was no match for the perfect storm. Ladies and gentlemen of the jury, the judge is going to explain what negligence is, and he will explain to you that when you do everything reasonable and you act as any reasonable person would have, it is in fact the very opposite of negligence. On the night of November 14th, 2019, here's what should have happened to Miss Canadian. She should have enjoyed another fantastic trivia night victory with her teammates. She should have been able to drop Bud Light and her car off safely at their destination. And Miss Canadian should have woke up to teach the next morning feeling a fever of excitement thinking about the night before. And she should have had the chance to look forward to her second date with Bud Light. Now, instead, Miss Canadian was subjected to a series of misfortunate events that she did nothing to cause and that she could in no way avoid. Miss Canadian followed all the rules of the road, and Miss Canadian was doing everything reasonable to get Bud Light and her car home safely. Now, Mr. Skiver told a story that Miss Canadian had no headlights on when she was driving. This is a fabrication by the defense. It has never been brought up until today. There is no police report. Mr. Skiver got charged with this accident, not her. It has been brought up by someone who has an interest in saying it, and they never cross-examined Miss Canadian about it. It is a lie. Give it no weight in your deliberations. There is absolutely nothing she or anyone else in her position could have done to prevent something as unpredictable as the traffic lights malfunctioning. And as Miss Canadian entered that perfect storm, Mr. Skiver's negligent driving meant that, as stated in his own testimony, he was driving his large tractor dangerously fast into the intersection. Now, dangerously fast in a large tractor meant that Miss Canadian was at the mercy of not only these malfunctioning lights, but the violent speed at which Mr. Skiver entered the intersection, giving Miss Canadian no time to anticipate and maneuver out of the way. Just like the weatherman in the perfect storm, no one would have been able to predict something like this. And just like the fisherman, there is nothing she could have done to prevent the collision of the perfect storm. Of all the people that night, who was in the best position to assess Miss Canadian's sobriety? It has to be the person sitting right next to her. As we heard in Bud Light's own testimony, she trusted Miss Canadian to get her home safely. And if it's not Bud Light, well, the next person in line would have to be the tavern. The Smart Serve Tavern confirmed in their own words that Miss Canadian was in fact sober when she left the bar. There had been evidence that indicated that there was a failed breathalyzer, however. But you did hear evidence from Molson that at no point in time did she ever fail a breathalyzer, and that she took all the usual tests at the hospital and when visited by the police. Now, this is her evidence, and no one has come forward with a breathalyzer test and put it into evidence. Ladies and gentlemen, I ask you, what would a reasonable person have done knowing that they had 3 drinks all night and were perfectly capable of following all the rules of the road? What would a reasonable person have done when a light turns yellow and you're entering the intersection? What would a reasonable person do when a large vehicle comes speeding on your right? Wouldn't the reasonable person do exactly what Miss Canadian did? Had it not been for the malfunctioning traffic lights, Miss Canadian would have made it home safe that night. Had it not been for the dangerous driving of Mr. Skiver, Miss Canadian would have made it home that night. And had it not been for the negligence and reckless behavior of others causing this perfect storm, we would in fact not be here today. Ladies and gentlemen, we are not trying to make excuses for Miss Canadian. That's not what this perfect storm is all about. As a jury, you will have to go through and determine whether she acted reasonably. You really have to examine her behavior. She went on a date. She decided to drive Bud Light in her car home. She was driving safely as any reasonable person would. But she could have never have predicted that the traffic light was malfunctioning or that Mr. Skiver would be violently driving through that intersection. Despite the fact a reasonable person did all these things, you can still have an accident and you can still have a perfect storm. But that does not make it Miss Canadian's responsibility. Justice, ladies and gentlemen of the jury, based on all the evidence, we ask that you dismiss this action against Miss Canadian and find that she is not responsible for the accident, because who can ever claim responsibility for the perfect storm? Thank you, Your Honor.
Thank you. Counsel for Mr. Beer. You ready with your closing?
I am ready. Thank you very much. As mentioned earlier today, my name is Zach Workington, co-counsel for Wish Your Beer Tavern. Members of the jury, Your Honor, the case against the defendant, Wish Your Beer Tavern, will be decided on 3 issues. First, whether the tavern met the standard of care for a commercial host on the night of November 14th, 2019. 2, if so, where the injuries that occurred to the plaintiff were caused by that failure to meet the standard of care. And 3, if so, how much liability, if any, should be put on Wish Your Beer Tavern. An important thing to remember is that the plaintiff and the other defendants are the ones that need to prove that Wish Your Beer Tavern is liable for the plaintiff's injuries. It is not Wish Your Beer Tavern that needs to prove that they acted responsibly. It's on the other parties involved to prove that they did not. And this brings me to my first issue: whether the tavern failed to meet the standard of care for a commercial host on November 14th, 2019. The rule for commercial host liability is this: liability may be imposed on a commercial host where a patron who subsequently causes injury has been served while intoxicated or overserved to the point of intoxication, and it is reasonably foreseeable that the patron will drive after leaving the establishment. Now that we have the rule in place, I want you to keep that in mind. I'm going to take us through what we learned about Wish Your Beer Tavern and the night of November 14th, 2019. While I do so, think about how that rule for commercial host liability applies to this evidence. We heard that Wish Your Beer Tavern runs a tight ship with employees that they trust. We heard that the hiring process at the tavern is rigorous. The owner of the tavern, Mr. Brown, ensures the people he hires to serve alcohol are knowledgeable of their responsibilities when they are working. The tavern itself has policies and procedures in place for when someone at the bar is showing signs of intoxication. Remember, do not serve. The plaintiff and the defendant, Molson Canadian, were at Wish Your Beer Tavern for roughly 3 hours that night. Their team won the trivia competition. The plaintiff and Molson Canadian were seated with 6 others, 8 in total at their table. The table enjoyed a few pitchers of beer and ate some pizza and wings throughout the night. Molson Canadian offered to drive the plaintiff home after the trivia contest, which ended around 9 p.m. Now, we've heard multiple people comment on Molson Canadian's sobriety that night. The plaintiff said in her examination that she had no concern about Molson's driving. We heard Molson Canadian in their examination say that the server at the tavern asked if they were good to drive. Molson Canadian responded that she was in fact good to drive. And the staff at Wish Your Beer Tavern did not see signs of intoxication from Molson Canadian. You have heard this point echo throughout this trial. The plaintiff gave Molson Canadian their keys and trusted Molson Canadian to get them home safely. This decision was made after the plaintiff and Molson Canadian had spent the evening together. And finally, it was a spur-of-the-moment decision for Molson Canadian to drive that night. He did not drive to the tavern. There really was no indication that he was planning on driving. She was planning on driving, my apologies. When you put all these pieces together, the evidence shows that on the night of November 14th, 2019, Wish Your Beer Tavern did not serve Molson Canadian while intoxicated, nor to the point of intoxication. And if they did, it was not reasonably foreseeable that Molson Canadian would drive after leaving. I'd like to highlight that it's not inherently wrong to serve alcohol to patrons at a bar, nor to advertise a trivia night. Remember, if Wish Your Beer Tavern breached the standard of care to find them liable at this tribunal, there must be a connection between the breach and the plaintiff's injuries. I say that so we do not lose sight of what really happened the night of November 14th, 2019. With that, I move to my second issue. If the tavern did not meet the standard of care on November 14th, 2019, the second issue is whether this caused the injuries to the plaintiff. Let's review what we heard about the accident that led to the plaintiff's injuries. Molson Canadian was driving eastbound on Main Street. There was an open pit on the northeast corner of the intersection of 1st and Main. That pit was created by Destructive Construction, Inc. The intersection had little, if any, warning signage, such as construction ahead signs, to warn motorists of the dangers of the pit that was ahead. The intersection also had little, if any, physical protection around the pit, such as A-frame barriers and orange construction cones. Destructive Construction, Inc. had an upcoming project that they were eager to start. Now, before getting confirmation from the city of Bedlam, Destructive Construction, Inc. removed warning signage. They removed construction cones, and they removed A-frame barriers from around the intersection. When Destructive Construction, Inc. removed these safety precautions, I remind you, there was still an open pit in the northeast corner of the intersection. Now, the traffic light at 1st and Main Street. The traffic light at the intersection was not timed properly. Southbound traffic would get a green light, while eastbound traffic may still have had a yellow. The city of Bedlam knew about this timing issue. Rather than fixing the light, they chose to ignore it because it was, as they put it, less than a blink of an eye. But the blink of an eye may be all that is needed for a car accident to occur. In fact, you've heard the plaintiff, Molson Canadian, and Wiley Skyver all state that the accident happened all of a sudden. Some might say it happened in the blink of an eye. Now, Molson Canadian. On the night of November 14th, 2019, Molson Canadian challenged a yellow light at the intersection of 1st and Main and attempted to accelerate through. Remember, Molson Canadian was driving the plaintiff's car eastbound on Main Street, meaning that their light may still have been yellow, while oncoming traffic, southbound, may have already gotten a green. All the while, Wiley Skyver was driving his truck southbound and approaching the intersection of First and Main. That night, Wiley Skyver was bobtailing when he was driving his truck home. As he said it, this did not allow him to use his brakes upon entering the intersection. Wiley Skyver knew that they were crossing a road where bobtailing was not permitted and decided to do so anyways. When Wiley Skyver collided with the plaintiff's vehicle, driven by Molson Canadian, the vehicle rolled into the pit on the northeast corner of the intersection. And remember, the City of Bedlam contracted Destructive Construction, Inc. to create that pit. Now that we've reviewed the facts of the accident, I'd like to run through a causation analysis. Basically, I'm going to start at the end of the accident and work my way back, seeing who and what caused this accident to occur. The plaintiff's car rolled into the pit at the northeast corner of the intersection. This was caused by Destructive Construction, Inc.'s decision to remove physical barriers from around the intersection. Molson Canadian drove the plaintiff's car into the intersection and was hit by Wiley Skyver. This was caused by Molson Canadian's decision to accelerate into the intersection to try to beat the yellow. Wiley Skyver was not able to use his brakes at the intersection of First and Main. This was caused by Wiley Skyver's decision to bobtail his truck home. While Wiley Skyver got a green light for southbound traffic at First and Main, Molson Canadian may still have had a yellow for eastbound traffic at First and Main. This was caused by the City of Bedlam ignoring the issue with the traffic lights. Molson Canadian was unaware of the pit at the northeast corner of the intersection of First and Main. This was caused by Destructive Construction, Inc.'s decision to remove warning signs from along the street. And finally, the plaintiff was in the vehicle when Molson Canadian drove into the intersection. This was caused by the decision of the plaintiff to give Molson Canadian their keys and permission to drive home. When the events leading to the accident are laid out piece by piece, one cannot come to the conclusion that this accident was caused by the plaintiff and Molson Canadian sharing drinks at Wish You Were Beer Tavern. When the accident is broken down into frame-by-frame incidents, it paints a picture of, I'm going to borrow this from my previous counsel, a perfect storm of poor decision-making made by those involved, far removed from what occurred at Wish You Were Beer Tavern on November 14th, 2019. This brings me to my third issue. If you find that Wish You Were Beer Tavern did not meet the standard of care and that they had a hand in causing the accident, then how at fault is Wish You Were Beer Tavern? With everything that we've heard today, if you find that Wish Your Beer Tavern is liable for the plaintiff's accidents, it must only be for a small portion. The important facts of each party I want to re-highlight are: multiple people commented on how Molson Canadian showed no signs of intoxication when leaving the bar. The plaintiff decided to trust Molson Canadian with their keys after spending the evening together. The City of Bedlam knew of the issue with the traffic lights of First and Main, chose not to act. Destructive Construction, Inc. purposefully removed safety equipment from the intersection of First and Main, regardless of the dangerous road conditions that they themselves created. Molson Canadian decided to challenge the yellow light at the intersection of First and Main and accelerated into it. And finally, Wiley Skyver chose to bobtail his truck home. Wiley Skyver knew bobtailing impaired his ability to use his brakes. When you look at the decisions made by all parties involved, it doesn't matter that Molson Canadian and the plaintiff shared drinks while playing trivia at a tavern kilometers from the intersection of First and Main. Therefore, if you find that Wish Your Beer Tavern contributed to the accident, it was a minimal contribution. Members of the jury, Your Honor, allow me to conclude with this final message. Wish Your Beer Tavern has been in business since 1996. That's over 27 years of business. A business does not last that long by fluke. You see restaurants and bars come and go all the time. Wish Your Beer Tavern is different. Wish Your Beer Tavern is a tightly run establishment. Wish Your Beer Tavern has trusted employees. Wish Your Beer Tavern takes the safety of their patrons seriously. The only thing that Wish Your Beer Tavern is guilty of on the night of November 14th, 2019 is hosting a successful trivia night. Thank you, members of the jury. Your Honor, that concludes my closing address.
Thank you very much, Mr. Workington. Counsel for DC Inc.
Yes, Your Honor.
Yes. Go ahead, Ms. Sacco.
Thank you, Your Honor. My name is Melissa Hocko. I am representing DCI, and I am from Queen's University. Members of the jury, as my colleague, Ms. Virgin, stated at the beginning of this trial, this is a case about doing your job. Now, based on all the evidence that you've heard here today, from witness testimony to documentary evidence, the only logical conclusion to draw is that DCI did its job. DCI did what was required of them according to their contract with the city and more. I will first suggest the key questions at play for you to consider when thinking about DCI in this case. I will then discuss the contract at issue here and how DCI fully and completely did their job according to that contract with the city. Finally, I will remind you of the many irresponsible forces that were already in motion by the other defendants before DCI even enters the picture. Forces which would have resulted in Miss Light's injuries, regardless of any actions taken by DCI and their role as a contractor for the city. Members of the jury, as Justice Carey will explain to you, the plaintiff has to prove on a balance of probabilities, meaning it's more likely than not, that DCI acted or failed to act in a negligent manner, causing the plaintiff's injuries. You've heard a number of metaphors today, metaphors like the perfect storm or an orchestra. But when thinking about DCI, there are only two main questions to consider. One, did DCI do their job in a reasonable and responsible manner? And two, did any of DCI's actions or omissions cause the car accident and the injuries suffered by the plaintiff, Miss Light? The plaintiff must prove that both of the answers to these questions are more likely yes than no in order to find my client liable for Miss Light's injuries. Let's begin with what DCI had to do as a contractor for the city. They were hired by the city to dig up part of the road, replace sewage pipes, refill the area with gravel, and repave it. You heard evidence today that DCI performed that contract properly and were paid in full. The work was originally scheduled to be completed on November 16th, as the witness for the city alluded to. However, DCI worked diligently. They fixed the sewage pipes ahead of schedule. They'd substantially completed the project before November 14th. And as you heard Ms. Marinelli explain, DCI called the city, the construction department that hired them, before November 14th to let them know they'd reached substantial completion on the project. Substantial completion means that the contractor completed the point of the project, the bulk of the work. In this case, replacing sewage pipes. So they were ready for use again. It also has two other effects: switching control of the intersection from DCI back to the city and triggering payment for DCI. And by control of the area, of course, we are referring to things like safety, signage, speed limits, and the like. You heard evidence that DCI had another contract lined up. This is true. It's common in the construction business. Therefore, they removed some unneeded signage from First and Main to move to their next site. DCI did so after appropriately informing the city of their progress. Indeed, you heard from the city's witness that it is up to the contractors to decide what is appropriate in terms of signage and safety and the like at their construction sites. Most importantly, DC always kept safety top of mind, both for drivers and for their workers. DCI did the responsible thing. They left significant and highly visible signage, barricades, and barrels behind to keep people on First and Main safe. I would also ask you to recall that A-frame barriers, barrels, and signage are portable, they're movable, and they are not meant to be fixed to the ground or to stop cars colliding from going over into the construction area. Unfortunately for the plaintiff, DCI doing the responsible thing and doing their job right was not enough to keep them from harm. This is because many others, before DCI even entered the picture, acted recklessly and irresponsibly. And it was those reckless and irresponsible actions by the other defendants that caused Miss Light's injuries. So let's discuss those other defendants and a series of poor choices that resulted in an all too preventable car accident. We can see how 4 failures unfolded throughout the night of November 14th, 2019. First, we have the defendant, Mr. Brown, the owner of the tavern. The tavern, of course, being understaffed on a busy night, a night that they knew would be busy because they took steps to thoroughly advertise a popular trivia night, which served food and alcohol. For a group of 8, we know 6 pitchers were delivered to the table, according to tavern records. In addition, we know from testimony that the group took turns ordering more pitchers from the bar. How many? We don't know that. The tavern did not bring forward any evidence from the bartender working that night. He's not here to tell us how, if at all, drinks from the bar were being counted alongside served drinks. Even more striking, the bartender in question had only worked 2 weeks total and had not provided the Smart Serve certificate required by law. I would also like to bring attention to Mr. Brown, the tavern owner's testimony, and remind you that counsel for Miss Canadian cross-examined Mr. Brown. Members of the jury, I would like to remind you that both Miss Canadian and Mr. Brown's interests are aligned in at least one sense. Neither wants the jury to find that Miss Canadian was overserved and therefore intoxicated. The cross-examination of Mr. Brown was filled with softball questions designed to elicit favorable evidence for Miss Canadian as well. Therefore, I urge you to place little weight on the evidence from this cross of Mr. Brown. We also know that after all those beers, the group was still able to order a round of shots only 15 minutes before leaving to drive home. And this is the first failure of the night. The tavern was understaffed on an expected busy night, employed an unqualified bartender without Smart Serve. And for those reasons, we ask you, the jury, to find the tavern was negligent. They failed their duty to their patrons by overserving Miss Light and Miss Canadian to the point of intoxication and overlooking the car keys that they had in hand. The second failure belongs to Miss Canadian. The plaintiff felt unsafe to drive, and Miss Canadian offered to drive her home. We can conclude from Miss Light and Miss Canadian's testimony that Miss Canadian drank too much to be safely driving home that night. The beers, the last-minute shots, not eating much food, all of these factors should have signaled to Miss Canadian that she was already intoxicated. Yet she chose to drive an unfamiliar vehicle in an unfamiliar neighborhood at night while inebriated. She did not heed construction zone ahead signs along Main Street. She rushed through the yellow light at the intersection without looking for potential hazards like oncoming traffic. Therefore, we are asking you, the jury, to recognize the major role that Miss Canadian played in causing Miss Light's injuries. Her choice to drive recklessly while intoxicated directly caused the car collision with Mr. Skyver, which injured Miss Light. And this brings us to our third failure, Mr. Skyver. As a self-employed truck driver, Mr. Skyver was aware of the dangers inherent in bobtailing without the tractor attached. We know from his testimony that he was aware he was crossing Main Street, a Class 2 roadway. We know that Main Street is classed that way because it's busy. It can often require quick break-in from drivers. And a driver cannot do that safely while bobtailing. With his experience and expertise as a professional driver, Mr. Scriver should have been driving with extreme caution, especially when crossing that intersection, so as to allow himself additional time to slow down and brake. However, as we know from his testimony, he was tired that day, had worked a 12-hour shift, it was 8 p.m., and he was nearly home. In his testimony, Mr. Scriver insisted he had a green light, and we're not arguing against that. However, as any driver, and certainly any professional driver knows, traffic lights do not let drivers off the hook for one of the most fundamental requirements of having a license. Look where you're going and look to see if any other cars are coming. We cannot forget the basic facts of this case. Miss Light was injured because Mr. Scriver's bobtailing truck hit her car. Mr. Scriver failed in his duty to drive with extra caution that day, to give himself plenty of time to slow down, to brake, and to keep an eye out for cars along the way. Therefore, we are asking the jury to find that Mr. Scriver is also negligent. And finally, the fourth failure was the city's traffic light glitch, or desynchronization, as it was called. They claimed they were not aware of this desynchronization, which caused a green and yellow light to be possible at the same time on the night of November 14th at that intersection, though it was apparent from the records after the fact. The witness for the city claimed that this was an imperceptible difference for drivers, but we have had two drivers now claim that they had the right of way and that they collided as a result of having a green or yellow light. Therefore, it's up to the jury to decide who to believe in this case. In any case, if the city was not aware of this desynchronization on November 14th, then it follows that the other parties, like Ms. Canadian, Mr. Scriver, and DCI, could not possibly have been aware of the extremely dangerous and potentially lethal flaw in the traffic lights. We heard during cross-examination from the city's witness and during DCI's testimony that the departments responsible for traffic control and construction contracts are two different departments in the city. As DCI, Ms. Marinelli told us, DCI's obligation in terms of notifying the city about the substantial completion benchmark was to the construction department, not to the traffic control division. While the witness for the city professed to know the details and be privy to everything regarding contracts between contractors and the city, we know from DCI that their contractual relationship was with the construction department, not with the traffic control division. Therefore, any communication that did or did not happen between those two departments at the city was not up to DCI to be involved in. The witness for the city also acknowledged that it is up to the contractors to determine what safety measures are required to keep drivers and pedestrians safe on construction sites. These measures can include things like barrels, signage, speed limits, four-way red traffic lights. It is up to the contractors to decide based on their expertise, and DCI decided so appropriately. In fact, we have no witnesses here today who can tell us that these measures were insufficient. DCI did what they knew would be right in terms of the safety of drivers and pedestrians. Finally, we would like to remind you, the jury, that it was the city and only the city who could have had full knowledge of the intersection's disastrous potential. Just as much, it was the city's breakdown in communication here, just as much as their breakdown in the traffic light system that caused the car collision and Miss Light's injuries. The truth is that the factors that led to this car accident and the plaintiff's injuries were already in place and in action before DCI even enters the picture. Regardless of any actions taken by DCI at the end of their contract with the city, the plaintiff and Miss Canadian would still have been overserved by the understaffed tavern. They would still have gotten into that car and driven while intoxicated. Mr. Scriver would still have been driving a bit too fast while bobtailing after a long shift. and the traffic lights would still have been out of sync. What matters is what caused the plaintiff's injuries. All of these events that I've just listed were what led to the ultimate cause of the plaintiff's injuries, the car collision. The plaintiff and Miss Canadian did not get into their accident because they saw 2 construction head signs instead of 3. They did not get into their accident because a pit suddenly opened up in front of them without warnings or barriers. There was an A-frame barrier found under the car. They got into their accident because of the choices made by the other defendants here. They got into their accident because of drinking, slow brakes, and dangerously out of sync traffic lights. I would like to remind the jury of those 2 questions I asked them to consider at the beginning of my statement. Did DCI do their job reasonably and responsibly? And did DCI cause the car accident that resulted in Ms. Light's injuries? Based on all the evidence you've heard here today, we are asking you to find that DCI did their job. They did it right. And they did not cause Ms. Light's injuries. We are asking you to find that DCI is not liable for harms they did not cause to Ms. Light. Thank you for your time and attention.
Thank you, Ms. Hako. Counsel for Mr. Skiver, are you ready to address the jury?
Thank you, Your Honor. Jessica Stinson for the defendant, Wiley Skiver. I apologize, Your Honor. Before I begin my closing, there are a couple of things that I would like to address. I'm loath to interrupt counsel during their closing arguments, so I didn't want to do that. But I do have 2 objections that I would like to get on the record for my friend, my friend for the defendant, Molson Canadian's closing arguments that I do feel I need to address before we proceed. That was the first closing that you heard.
Well, at this point, the evidence or the if you're objecting now to something said in the summaries.
That's correct. In the closing address.
All right. Well, I mean, you can. I don't know if it is an objection. I think it's something that you can point out to the jury, but at this point, if I agree that there was something said that shouldn't have been said, I will indicate that to the jury. So I'll hear you on what you have to say. You have the advantage of having heard 4 of the or 3 of the other counsel already, and there's 2 more to hear from. So just
thank you, Your Honor. Perhaps if I could
just go ahead.
There is just one point that I'll address that I believe said that shouldn't have been said. My friend from Molson Canadian referred in his closing to charges that Mr. Skiver received. These charges were disclosed. They were not, they were not addressed during Mr. Skiver's testimony. He was not cross-examined on these charges during his testimony, Your Honor, and that's because these charges were ultimately dropped and not pursued by the prosecution. And I would submit that because he was not cross-examined on these charges, it's not appropriate for that to be put in a closing argument as this testimony.
I didn't see that fact in the summary that I had of the facts, but we can.
I would just ask that the jury.
Sure.
Jury be instructed to disregard that, as that's not been given in the testimony today.
Right.
Thank you. Thank you very much.
So, all right, and I take it you want that to be an objection and not to be cutting into your time, but I think the time has already started.
Oh, okay.
Right.
I didn't intend for that to be an objection, but I can get started now if you're ready, Your Honor.
Okay. Oh. Time has not been started, so you can, you've got your full time. Go ahead.
Thank you very much. Thank you. Some things in life are within our power to control. We have the ability to make a choice and change the outcome, but sometimes we don't. We simply find ourselves at the wrong place at the wrong time. Many choices were made by the various parties that you heard from today, leading up to the accident on November the 14th, 2019. Choices that could have or should have been different. Choices that, if they had been different, may have prevented this accident from occurring. But Mr. Skiver's choices that night aren't amongst them. Mr. Skiver's choices that night were reasonable. He took all standard precautions anyone would have on a regular commute home from work. He simply found himself at the wrong place at the wrong time. I'm only going to be focusing on Mr. Skiver's involvement in this accident. And there are 4 main points I'd like to make as to why you should accept Mr. Skiver's evidence and find that he was in no way responsible for this accident. First, Mr. Skiver was completely sober and paying attention to the road that night, while Mr. Canadian wasn't. Second, Ms. Canadian was driving with her headlights off, and as a result, Mr. Skiver was unable to see Ms. Light's darkly colored truck approaching a dimly lit intersection. Third, Mr. Skiver had the right of way on a green light, while Ms. Canadian was speeding through a red light. And fourth, by the time Mr. Skiver was able to see Ms. Light's truck, he simply didn't have time to stop, regardless of whether he was bobtailing or not. Mr. Skiver is a highly experienced semi-truck driver. On the night of the accident, he was at all times driving in a lawful, a careful, and a sensible manner. He wasn't distracted while he was driving. You heard from him that he wasn't eating or talking on his phone. He was sober and he was paying attention to the road. Mr. Skiver approached the intersection, and having a red light at first, he slowed his truck to less than 25 kilometers an hour, and he began braking to stop. When he was a few car lengths back from the intersection, his light turned green. That evidence has not been disputed here today. As he told you, he looked to see that the intersection was clear. He didn't see any vehicles in or approaching the intersection. He didn't see any headlights approaching the intersection. So he began to accelerate into the intersection, just as any driver would have. He was alert and he was paying attention to the road and to his surroundings. On the other hand, Ms. Canadian had been drinking at the bar that night and took a tequila shot right before she decided to drive. And we heard from both Ms. Light and Ms. Canadian that they were having a great time in the car on their way home. They were listening to music, they were singing along, they were enjoying the end of their first date, and they were still celebrating their trivia win. Ms. Light told you she wasn't really paying much attention to the road around her. And I'm going to suggest to you that Ms. Canadian wasn't really focused on the road around her or her own driving either. Ms. Canadian told you that she saw Mr. Skiver's semi-truck approaching the intersection, and she said she saw it going a reasonable speed. If she was focused on her driving and she saw a large white semi-truck approaching the intersection at a reasonable rate of speed, as she said, why then did she decide to speed up and try to beat the light? Also, I'd like you to ask yourselves, if Ms. Canadian was paying attention to the road, how could she have missed the torn up road and the construction pit with the A-frame barriers that were directly ahead of her? And this brings me to my second point, that Ms. Canadian didn't have her headlights on that night. Mr. Skiver told you that Ms. Light's car didn't have his headlights on. Now, my friend has suggested that this evidence has been fabricated because Mr. Skiver wasn't asked about this evidence before today. Members of the jury, the physical evidence that we know about the intersection supports Mr. Skiver's evidence that Ms. Canadian's headlights weren't on. And it is not Mr. Skiver's fault that counsel for my friends, my counsel for the other defendants and the plaintiff haven't asked Mr. Skiver about this before today. I'm going to take you through the physical evidence that supports Mr. Skiver's evidence on this point. You heard from Ms. Marinelli, the witness for DC Inc., and you heard from Mr. Skiver that reflective A-frame barriers were set up around the construction pit, around the perimeter of it, that was directly in front of Ms. Canadian. And any car with its headlights on that night would have seen those reflective barriers. Mr. Skiver told you his headlights were on his truck and they picked up the reflective barriers that were around the construction pit. We also heard from Ms. Marinelli that when DC Inc. returned to the construction site the day after the accident, the A-frame barriers were still there on site, although by that time they had been placed by the side of the road. Ms. Canadian said she didn't see any of the construction signs or barriers or anything like that. The reflective barriers that she would have been driving straight toward, that her headlights would have picked up if they were on. But one of those reflective barriers ended up underneath Miss Light's vehicle after it was pushed across the intersection and into the construction pit. Miss Light told you that herself. Miss Canadian clearly ran over one of those reflective barriers as the car made its way into the pit. If her headlights were on, why didn't she see it when she was driving straight at it? She didn't see the reflective barrier or that she was headed straight toward a construction pit for that matter, because in addition to not paying reasonable attention that night, her headlights weren't on. And as a result, Mr. Skiver couldn't see Ms. Light's darkly colored truck driving up a dimly lit main street toward the intersection until it was essentially right in front of him. He had no warning and he had no time to react. And suddenly, unavoidably, he collided with Ms. Light's vehicle. The third point that I would like to discuss is that Mr. Skiver had a green light. He had the right of way. But what about the light malfunctioning? Mr. Skiver told you that Miss Canadian's light was red. Miss Canadian told you that it was yellow. You'll have to decide whose evidence you prefer. We heard from Miss Peltier from the city that there is a red overlap with lights, and that the 0.2 second delay meant both lanes would have a red light at the same time for 1.1 seconds rather than 1.3 seconds. In other words, the 0.2 second delay would not change the fact that both lights would be red before Mr. Skiver's light turned green. And we know that Mr. Skiver's light turned from red to green when he was 2 to 3 car lengths away from the intersection while he was braking to stop. So Miss Canadian's light would have had to have been red by that time. Now, Miss Canadian said she entered the intersection first. Mr. Skiver told you that he entered first and Miss Canadian entered right after he did. I'd like you to recall that Mr. Skiver was driving substantially slower than Miss Canadian, beginning to accelerate from a speed of less than 25 kilometers an hour. And his truck had passed fully through the westbound lane and was already making its way into the eastbound lane of the intersection, while Miss Canadian's truck was still making its way through the first half of the intersection, going at a speed of, she had mentioned, maybe more than 10 kilometers over the speed limit. Regardless of who entered first, the evidence does suggest that Mr. Skiver entered first, but regardless, they would have entered around very close to the same time. And Miss Canadian's light would have surely been red by the time she was entering that intersection. Miss Canadian simply had no regard for how long that light had been yellow when she made the choice to speed up and beat the red light. The final point that I'd like to make is that Mr. Skiver did not have time to stop before the collision. Ms. Light's truck appeared suddenly in front of him without any warning, no headlights on, in a darkly lit intersection, speeding through a red light. Mr. Skiver had no opportunity to avoid it. He simply didn't have the time. There was no choice available to Mr. Skiver to change that outcome. As soon as he could react, Mr. Skiver immediately geared down and tried to brake, but it was too late and the collision had already occurred. Mr. Skiver's bobtailing makes no difference in the fact that by the time he was able to see Miss Light's vehicle coming out of the darkness, Mr. Skiver had no time to brake. As he told you, it wouldn't have mattered if he had his loaded trailer attached or even if he was driving a car. He simply didn't have time to stop before the collision. And Mr. Skiver did nothing wrong by bobtailing that night. Bobtailing on First Street is permitted by law. And Mr. Skiver had specifically outfitted his semi-truck and adjusted his driving to bobtail in a safe manner. Mr. Skiver's bobtailing had absolutely no bearing on this accident occurring. At the earliest opportunity that he could safely bring his vehicle to a stop, Mr. Skiver did so, and he immediately called 911, checked on Miss Light and Miss Canadian, and told them to stay in their car until help arrived. He stayed on scene and he waited for the ambulance. He wanted to make sure Miss Light and Miss Canadian would be okay. That was Mr. Skiver's involvement in this accident. He took all reasonable precautions any responsible driver would have that night. And there are many ways this accident could have been avoided, but not by any action that was available to Mr. Skiver. Perhaps if the tavern hadn't been understaffed and could keep better track of how much alcohol their patrons were consuming. Or perhaps if Ms. Canadian didn't drive after a night of drinking or was paying more attention to the road. Perhaps if there was more construction signs on the road that night, or if a four-way stop had been set up to control traffic. Perhaps if any one of those actions had occurred, this accident might not have happened. But none of those actions were taken, and none of those actions were within the control of Mr. Skiver to take. There was no choice available to Mr. Skiver that he could have made differently that would have allowed him to avoid this accident. Mr. Skiver was caught up in this accident, but he was not the cause or even a cause of this accident. We ask you to dismiss the claim against Mr. Skiver. Thank you.
Thank you very much. That really completes the defendants.
Your Honor, if I may respond to my friends at Osgood.
Sorry. I think there's okay. No, I haven't heard from the city. Sorry. Yes, you wish to respond to. What I would prefer, if there's objections to the summations, that they take place in the absence of the jury, and that we wait till all of the submissions have been made.
Absolutely, Your Honor.
All right. Yes. City lawyers' submissions, please.
Yes, Your Honor, we're ready.
Okay. Go ahead.
Good evening, Your Honor, members of the jury. This morning, you heard that life is like an orchestra, each person playing their part. However, unlike an orchestra, life is not flawlessly rehearsed and mistakes are often made. Just as on November 14th, 2019, an ordinary night of trivia and drinks ended in a car accident. An accident that could have been avoided if not for some cut corners. The plaintiff, B. Light, claims that the city of Bedlam was responsible in the accident at Main and First Street. However, the evidence heard over the course of this trial shows that the city was reasonable and responsible in its actions. I will first address how this accident came to be before addressing the involvement of M. Canadian, B. Light, Wish You Were Beer Tavern, Destructive Constructive Inc., Mr. Skiver, and then concluding with the city of Bedlam's position. The evening started with a missed appointment. B-Light's car was subject to an urgent recall regarding the steering wheel, and she was supposed to take the car in for repairs. Except it wasn't important enough, as she forgot the date and went drinking instead. The issue was forgotten entirely, as B-Light, M. Canadian, and their group of friends drank alcohol and played trivia. A few hours went by, and B-Light accepted Canadian's offer to drive her home. They left the bar together. M. Canadian ran through a red light and was hit by Mr. Skiver, the tractor driver, at the intersection of Main and First Street. Their car slid into DCI's unfilled gravel pit, which is what brings us all here today. M. Canadian denies all fault in the accident, despite all that you've heard today. She was at the Wish You Were Beer Tavern for a few hours and drank beers with B-Light. Both of their testimony states just as much. How much beer? 2 pints at the least. as they ordered multiple pitchers and felt the need to order a couple more from the bartender as well. She also testified to not eating during this time. If that wasn't enough, she drank a tequila shot before leaving the bar, as confirmed by B Light. She offered to drive B Light's car on their first date. She drove at night, and B Light confirmed that it was extremely dark. It was raining, and she was already speeding above the limit before the intersection, and she accelerated through the light just before being struck. She claimed to be acting reasonably at the bar and reasonable while driving. But these actions sound reasonable. The A barrier found under the vehicle by Mr. Skeever would not think so otherwise. Oh, would not think so either. B Light has claimed no responsibility, and it is true that she did not serve the drinks or drive the car. However, it is also true that she failed to take her car in for repairs despite an urgent recall. Despite not choosing to drive from the tavern, it was ultimately a bad decision to allow Canadian, who she testified to blowing a 0.85, to drive her car and be a passenger. A mistake that could have been caught by the Wishy Root Beer Tavern, but was not. The tavern claims to have met its obligations and had no way of knowing Canadian was intoxicated or intending to drive that night. They claim this despite having 3 servers managing 24 tables full of customers on an advertised trivia night. Just one of these tables contained M Canadian, B Light, and 6 of their friends. The owner claimed the ratio of employees to guests was adequate. Adequate being 8 tables of up to 8 people, 1 server looking after up to 64 people. The tavern was short-staffed on one of their busiest nights, but still claimed to be attentive and responsible. The owner testified to understaffing being a common issue in the industry. It is a reality of their business, but it cannot serve as an excuse for failing to reasonably serve and monitor their customers. Furthermore, the owner of the tavern testified to never having received the smart serve of the bartender working that night. A smart serve is required for workers to serve alcohol at restaurants and bars. A new bartender, who may not even be licensed, would be likely to overserve and not see the hazard that they've created. Knowing this, it is of no surprise that the tavern was unaware of M Canadian's intoxication or intention to drive. Still, the damage may have been reduced, but for the actions of Destructive Constructive Inc. You heard counsel for DCI say they went above and beyond. I ask you, did they go above and beyond? You heard on November 14th, 2019, DCI pulled the signage for another project that it was starting. They did not have enough safety equipment to accommodate both, so they left a minimal viable product at First and Main. Workers were instructed to take down all but the essentials. What was essential? They left 2 construction ahead signs and a single A barrier and 1 orange barrel at each corner of the pit. Not even enough to cover the 4-way intersection. M Canadian testified to just that. She saw no barriers, barrels, or signs as she drove. DCI claims that they started to fill the pits and that the work was substantially done. The city now falling, the responsibility now falling on the city. This is bizarre because the plaintiff's car was found in a gravel pit that DCI still had to fill. And it's stated to be done on November 16th in the contract, with no communication to the contrary. It is difficult to imagine contracting for road repairs and receiving a half-filled pit as a completed objective, as claimed in Ms. Marinelli's testimony. The intersection and its safety was still under the construction company's control, despite its inadequacies. Mr. Skeever further testified to driving home after a 12-hour day. During his testimony, he explained bobtailing that night, the driving of a tractor without a trailer, which he knew was illegal on Class 2 highways like Main Street, but decided to do so anyway as he would only be crossing. Mr. Skeever still followed the steps expected of a reasonable driver. He geared down and slowed to stop for the red light. He saw it turn green and gradually accelerated as he changed gears. He testified to entering the intersection on a green a couple of seconds later, and he saw the other light as red in his peripheral vision. Molson ran a red light, ultimately being struck by the tractor. He was going too fast to brake, but for M Canadian, Mr. Skeever wouldn't have had to. The drivers claim that it was the city that was responsible for their accident, that the delay in changing colors caused the problem, and that the city was negligent in hiring DCI. The city denies these claims. The city does not specialize in construction and as such contracted to someone who does. In addressing the traffic lights, as Mr. Skeever's counsel, I too find it necessary to clarify some mischaracterizations presented by the Wish You Were Beer Tavern's counsel. The lights were not malfunctioning and they were not ignored by the city. There was no evidence presented that the city knew about the missynchronization prior to the accident. Members of the jury, I will remind you that the council is not allowed to submit evidence, only witnesses. Ms. Pelletier's actual testimony shows that the delay was not discovered until after the accident had happened. It shows that the delay between green on Main Street and the red on First Street was inconsequential. The delay reduced the all red period from 1.3 seconds to 1.1. The provincial standard requires at least a 1 second all red period, meaning that the city met the Ontario standard at all times. The difference, a 0.2 second delay, is a time frame so short as to be imperceivable. A delay shorter than the blink of an eye. The testimony from Ms. Marinelli, representing DCI, confirms just that. They were managing the site since repairs began and never noticed any issues. Members of the jury, you've heard some conflicting evidence today. It is your job to decide what you believe. B. Light testified to a close relationship with M. Canadian ruined by the accident, while M. Canadian claimed to be on their first date. B. Light testified to her blowing a 0.85 after the accident. M. Canadian and the tavern, who both have an interest in her sobriety, claimed that she was sober. Mr. Skeever, a professional driver heading home on a familiar road, saw a car run a red light. M. Canadian testified to driving on Main Street for the first time after leaving the bar. She claims to have accelerated through a yellow light instead. Based on all the testimony, it should be clear that there are multiple parties that cut corners that just weren't worth it, and ultimately contributed to B. Light's loss. The city of Bedlam, however, is not one of them. The city acted reasonably and could not have foreseen this unfortunate series of events. On this basis, the city of Bedlam should not be found liable for any damages. And if it is, the city should receive indemnity from the other defendants who actually caused the loss. Your Honor, members of the jury, subject to any questions, that concludes defense counsel submissions. Thank you.
I take it, given your submissions about the manner in which the city has conducted itself, that a name change from Bedlam to perhaps something less negative could be in order.
We would hope not. The city of Bedlam's had a long history and we proudly represent our constituents. Thank you, Justice Carey.
Thank you. I will call on the, thank you. I will call on the plaintiff's counsel. I take it that damages are to be addressed after the verdict. And I take it yes.
Yeah, that's the jury will go out afterwards and we'll answer the questions that were given to us.
Thank you. Yes, counsel for the plaintiff.
Your Honor, Justice Carey and members of the jury, thank you for your time during today's proceedings. My co-counsel, Tish Lewis, and I, Nicole D'Alessandro, are here today on behalf of the plaintiff, B. Light. You heard my co-counsel this morning tell you that this case is like an orchestra performing a song. There are different roles in an orchestra performance, and each role is key to making sure the performance is seamless. Any mistakes could cause a domino effect and throw the entire orchestra into chaos. Members of the jury, whether we realize it or not, we participate in a seamless orchestra every day. And in doing so, we rely on one another to play a specific part. But in this case, that did not happen. On behalf of the plaintiff, we urge that in your deliberations, you place the most weight on three major considerations that have emerged from today's evidence. First, the defendant, the City of Bedland, bears the most responsibility in this case. It was responsible for streetlights and maintaining traffic lights. And the city hired the construction company, DCI, to complete construction at Main Street and First Street, but the construction company did not complete its role. Second, after the city, the defendant, DCI, is almost as equally liable in this case. Before construction was completed, it removed critical signage at an intersection which should have remained completely blocked off in every direction. And third, the plaintiff, B. Light, made reasonable choices. She went to a trivia night and M. Canadian offered to drive her home. She accepted this ride because she trusted her. First, I'll begin by discussing the role of the defendant, the city. The city has significant power to decide what street lights and traffic lights will be placed where in the city and how these lights will be maintained. This is no minor responsibility, as drivers rely on the city for safe driving conditions. There is no room for error. Very few things in life are held to a standard of perfection, but traffic lights must be perfect. In this case, the lights were defective and off by 0.2 seconds. When driving, every second counts. While the city testified today that drivers would not notice a 0.2 second delay in the traffic lights or they would not perceive it, the plaintiff, B. Light, felt it. You have heard today from M. Canadian and B. Light that this intersection of Main Street and First Street, where the car crash took place, was not well lit. Both B. Light and M. Canadian state they were suddenly hit from the side, seemingly out of nowhere. And you've heard M. Canadian explain they could not see any other traffic on the road until the last minute. She did not see any A-frame construction signs. It is not a coincidence that a car crash happened at a dimly lit intersection with defective traffic lights. This car crash was waiting to happen. In the orchestra of life, the city failed to stay on beat. Based on its level of responsibility in this case, we submit the appropriate percentage of liability on the city is 45%. Next, let's talk about the role of the defendant, the construction company, and as they call themselves, DCI. You've heard from my friend that DCI went above and beyond and did their job. Respectfully, the evidence you heard today shows otherwise. If we think about this case as an orchestra, not only did DCI not play its part, it completely abandoned its role before completion. So how did DCI become involved and suddenly leave? Under a contract, the city hired DCI to repair a sewer line at the intersection of Main Street and First Street. To complete the construction, DCI put a number of construction zone warning signs at the intersection, completely blocking it off in each direction. But on the date of the car crash, the owner of DCI ordered that some construction signs were taken away from a construction zone that was not yet completely finished. Why did DCI do this? For profits. Quite simply, they removed construction zone signs at an intersection which should have been completely blocked off to make more money at another project. DCI told us today they did this because under the contract, the construction was substantially completed and the signs were needed elsewhere. But it is unreasonable to expect the safety of everyday drivers to be at the whim of a contract. Substantially complete is not complete. DCI testified a pit 2 meters deep remained at the intersection. DCI cannot have a laissez-faire attitude when dealing with public safety. Roads are incredibly important in our lives. They transport us, our children, and our loved ones every day. In the seamless orchestra of life, every role matters, but DCI was offbeat in their performance. Based on the conduct of DCI, we submit to the appropriate percentage of liability on them in this case is 35%. Next, let's talk about the role of the defendant, Wish You a Beer Tavern, and its owner, Mr. Brown. The tavern made the business decision to host a trivia night, hoping to attract a large crowd. Indeed, Mr. Brown told us that most of the customers at the tavern on the night of the car crash were there to attend trivia. Mr. Brown testified that he did not notice Be Light and M Canadian to be intoxicated. And this supports the notion that Be Light and M Canadian's drinking was not an issue. You also heard Mr. Brown testify that the bartender worked at the tavern 2 weeks without a Smart Serve certification. And Mr. Brown told us that he has lost contact with her. Time matters. 2 weeks is an unacceptable amount of time for such an oversight from a veteran business owner. Based on the tavern's actions, we submit to the appropriate percentage of liability on them in this case is 2.5%. Next, I will discuss the role of the driver of the tractor, W. Skyver. You heard Skyver, who has 15 years of experience as a tractor driver, admit to knowingly pass Main Street, which does not allow for bobtailing. You heard a lot about bobtailing today, but what is important to take away is that bobtailing is not permitted on Main Street. Skyver's excuse is that he did not plan to drive on Main Street, but as a driver, he must be able to redirect himself based on driving conditions. Skyver did not consider the elaborate orchestra of life and that our best plans impact others. Based on W. Skyver's actions, we submit to the appropriate percentage of liability on him in this case is 7.5%. Next, let's talk about M. Canadian. You heard M. Canadian testify today that she offered to drive Be Light home because she said she knew she could get herself and Be Light home safely. We submit that no reasonable driver would have entered an intersection if 8 frame construction signs had completely blocked it off. You also heard that B was nervous, and understandably so. She forgot the recall to her vehicle was urgent. But we direct you members of the jury to focus on that Molson, the driver of the vehicle, mentioned the steering was not an issue in the mechanics of the car crash. M. Canadian made the judgment call to proceed through a yellow light rather than stopping at the intersection, despite it being not well lit and driving at night. Based on this poor exercise of judgment, we submit to the appropriate percentage of liability on M. Canadian in this case is 10%. Finally, I want to discuss the impact of this car crash on our client, Be Light. If we think about this case like an orchestra, Be Light relied on the defendants here today to play their parts. Like all of us in her situation, B believed that each of the named defendants would accept their role in this elaborate orchestra and complete their duties with the utmost care. B told us about 4 major changes in her life because of this car crash. This car crash has impacted her job, her personal life, her health, and her future. Let's first talk about how this car crash has impacted B-Light's job. B-Light told us she had a job that she loved, working with animals at the Humane Society. But this car crash has left her unable to work, and she has long-term injuries from this car crash. She forgets how to do things at work, and she can't control her temper, which would make working at her job dangerous. She has tried to go back to work 2 separate times, but she is unable to do so. Prior to the car crash, B-Light earned $80,000 a year at the Humane Society, but she told us she now receives $24,000 in disability benefits, less than half of what she used to make, and she must pay for ongoing medical treatment because of the car crash. Next, let's turn to how the car crash has impacted B-Light's personal life. Before the car crash, B-Light had a passion for life, but this car crash has taken that away from her. Before the car crash, B-Light described herself as calm, happy, and joyful. She told us that while she used to feel sharp, she now can't remember many things and must constantly cope with memory loss. B-Light told you that she once enjoyed going out with friends, but she now spends most of her time at home, and she has no desire to go out anywhere. Next, let's talk about B-Light's health. If we could summarize her health in one word, it would be pain. B-Light has many physical injuries from the car crash, which she will not recover from further. She also has emotional pain in the form of driving anxiety, depression, and coping with how this car crash has changed her life. Finally, this car crash has significantly impacted B-Light's future. She envisioned a future for herself that included working with animals at a job that she loved, continuing her relationships with friends and loved ones, and staying active and enjoying fun hobbies. B-Light continues medical treatment for her physical injuries and therapy for her emotional health. But because of this car crash, B-Light's future looks very different. Members of the jury, for all these reasons, B-Light is seeking $5 million in damages and special damages plus costs. We submit to you that these damages are reasonable based on the injuries, the impact that this car crash has had on B-Light's life, and how it has changed her future. After taking a hard look at the evidence, the judgment will ultimately rest on you. We urge you to make this right and find in favor of the plaintiff. Thank you.
Thank you, Ms. D'Alessandro. Well, members of the jury, this is now when I address you, and I will address you briefly on your duty today. You are the finders of fact. There must be some evidence that you rely on to make your findings of fact. Essentially, 2 types of evidence in play here. In this case, there is direct evidence from the witnesses, and there's circumstantial evidence. Circumstantial evidence, for instance, if at the courthouse today, someone came in with snow on their coat and brushing snow off, you could likely assume that it was snowing outside. Or if on a summer day, someone comes in with an umbrella, shakes it off, you could likely assume that it was raining. I am the finder of the law and make the legal rulings. I would point out there was no law produced to support the suggestion that cross streets are included in any bylaw relating to driving without a trailer. It would be impossible for drivers to follow a law that included cross streets. And you can take it from me that if a piece of legislation talks about driving on a road, they're talking about the road ahead, and it does not include any cross streets. There was no evidence heard of any charges laid. And it may be that there were charges laid, but you did not hear about them in the trial today. And even if there were charges, just the laying of charges without any information about the results of those charges, whether there was they were proceeded with, is not helpful. So I instruct you to ignore any suggestion that you should conclude that charges were laid against any party. There was no evidence that a sobriety test was taken. There may have been, but I agree with counsel who pointed out that it was incumbent on any party who had the results of a sobriety test to rely, to call evidence of that. However, that does not mean that the sobriety of the driver is not in play. You could conclude on the evidence that you've heard that alcohol use by M. Canadian was a factor. There was evidence she was drinking. She gave evidence of what she had to drink and when she had the drinks, and she gave evidence of how she felt. You are the finders of fact on that issue. So those are my instructions to you. And if you have any questions in the jury room, you may send them out to me. And you will now follow the CSOs back to your jury room to deliberate. Thank you for your patience today, and we will await your decision.
Thank you, Your Honor. Sean, are you going to put us into a jury room? Do we have a link for that?
Yes, so the rooms are open. So how this is going to work, the jurors can go to their jury room and I'll put them there. Participants should stay in this room because Justice Carey, if he wishes, can provide some comments about his impressions of the competitors. So I actually just might pull some people out of their rooms. So while the jury's deliberating, feel free to, Justice Carey, if you have some comments about what you saw today, then I'm sure the competitors would appreciate that.
So, Your Honor, the jury will exit the courtroom now.
Good luck. And in terms of my comments, I will keep them general. Well, I may have formed impressions of each of you. The circumstances are such that I'm not going to single out any one of those. Some of my comments may arise from something one or some of you did, but I'll try to be general. First of all, this was a delight for me to yes, sorry.
My apologies, Your Honor. I actually have to send the coaches to a coach's room because they actually picked the best witness today.
Right.
So I will send the coaches to the coach's room for deliberations to determine.
I think they and the any other prizes have a tough job because it was a high level of competence in counsel and in the witnesses as well. I think I said earlier, and I'm not sure if the participants heard it, that I didn't know there was acting classes at the law school, or that we had some serious acting background to some of our witnesses. It certainly appeared that way. So are they off? Am I free to start rambling?
Yes, you are.
Okay. So I've made some comments, and I should get my screen up here. There were some, so I can see you all, and if everybody have their. I'm trying to get the view here, gallery view here. There we go. There you are, and a good-looking group you are. The so I have done this before, and over the years I've been involved as coach in moots, and I think I may have participated in one in law school, but certainly the moot today was highly entertaining, and you obviously all put a lot of work into your performances as counsel and as witnesses. Some general comments.
I'm very sorry, but I'm a coach and I did not make it into my breakout room for Western. I just don't want to listen in otherwise, sorry.
Okay, so are you going there? You can just turn
I
off.
had an option to go there from Sean, but I can also just sign out completely and text the main coach.
I've sent you to the room.
I believe you should be able to hit the breakout room button and join the coach room if you have the same view as me.
Okay, sorry. I also just didn't want to listen any further, but just a moment.
I'm sure your sentiments are shared by some of the participants. Just kidding.
Okay, I think we're good.
Okay, so the general comments that I have that I have here somewhere are, as I've said, it was very entertaining. It was, I would say this, it shows a good preparation to have the areas you're going to cover, and perhaps indicate that to the witness, but I don't think you need to, and especially if you're cross-examining, you are able to surprise a witness, catch them off guard. it's hard. It was hard to necessarily track whether you were making eye contact with the jury or with the witnesses, although there was some reading going on, and at least a couple of you seemed to have your speeches memorized or had very low reliance on notes. And if you can do that, that is a really good skill that allows you to interact with both the jury and the witness. And when you're reading, you're not able to get any feedback from either the witness or the jury. Now, of course, you can watch the jury when you're not on your feet, but there is also a flow and a natural ability in the listener to follow someone who is clearly talking directly to you and not looking down at notes. So that is something that I think good counsel will always try to do. And I was very impressed, though, that all of you knew your material very well, and to the extent that there were some of you who were able to speak without appearing to look at your notes, that is to your credit, and it's not meant as a criticism of anyone else. We had a few objections that came essentially too late. I think that you're constrained by some of the facts. I understood that as well in my instructions, that there may have been a difference in the facts in the summary and the facts in discovery, and that, I'm told, is the reason that there might have been some misunderstandings on the facts. I thought all of you kept the pace up very well. There wasn't lag or any indication that anyone was confused or lost their place. So clearly a lot of work has gone into all of your all of your submissions, and the preparation was quite visible. I did mention a couple of things to the jury that you of course heard. One about the cross street. I suppose one might give someone points for initiative, but if a bylaw was including cross streets, it would be unenforceable and it would be impossible to obey it. That's why it's called a cross street as opposed to the thoroughfare. And then I think it was appropriate. Again, I don't know what evidence there was of charges. There may have been somewhere said that there were charges withdrawn. But if that was the case, withdrawn charges are not evidence of any wrongdoing. And if there was a sobriety test taken. That should have been properly put in evidence. There are a couple of stages with sobriety tests. If an officer believes a driver has been drinking and they acknowledge that they've been drinking, that may in itself be enough, and that usually is enough for there to be a demand. And usually it's a breathalyzer as opposed to a blood test, but there was just no evidence at all that this court heard that that was done. But as I indicated, one can imply that someone was affected by alcohol just on the facts that they admitted drinking. I believe the defendant, Molson Canadian, said she had five drinks over the course of 3 hours, but felt fine to drive. Liability can be founded without any evidence of hard evidence of either of drinking at all. It could be founded on careless, negligent driving, as was suggested by some counsel. The order of closing statements is a little bit arbitrary. It's based on, I think, the defendant's order in the claim. And of course, the plaintiff gets the last word, and that is appropriate, and it allows the plaintiff to hear everything everyone else has said and respond to it. But the onus is on the plaintiff, on the balance of probabilities, to prove the case, including damages. And obviously we had a short circuit trial here. If this was a real trial, I would have thought that it would, with all of the usual witnesses, it would probably be estimated at 2 to 3 weeks, maybe 4. I spend a lot of time estimating trials. I have in Windsor, and I know we've got some Windsor people here and some Windsor jury members, and they can confirm that. The other thing that really didn't jive with current reality was that this accident happened in 19, and you're having your trial now. That would be unusual, unfortunately, especially with the serious injuries. There are a lot of discoveries that take place, and experts. This case would probably have had a whole list of experts on damages, physiotherapists, psychiatrists. I think there was back injury. So there's a whole line of specialists, and both sides, typically in a motor vehicle personal injury case, there will be specialists from both sides. We now do see virtual trials, and we've had a lot of virtual trials. And as I commented at the beginning, there are a lot of advantages to virtual trials. First of all, there's advantages through the whole process to the litigants. Access to justice is doesn't require you to sit around all day waiting for your case to be called. If you're on a pretrial or if you're on a motion, you can listen to motions that normally, if you were a party, you would not listen to, civil motions, because they're civil motions are, at least in Windsor, scheduled 20 or 25 on a given date, and you never know when you're going to be reached. Most people are working, and if they're not working because of their injuries, they may have an inability to get to the courthouse. None of you were delayed today by weather, although we had a real dump in Kingston and I think across the province. Although I look out my window here and it's mostly gone from the streets. I was shoveling earlier today, and maybe some of you were, but you were able to participate. And is there anybody here who didn't have snow where they are today? Tell me the Lakehead had no snow.
We had lots of it.
Yeah, I saw you grinning there, and you usually do. And your school, well, I'm talking to somebody from Lakehead, and I know there's a bunch of you. It's a Bor-Alaskan Law School, and just two quick things about the law school. That, as you may know, was originally a high school, and my wife, who's also a graduate of Windsor Law School, and is now retired and had a long career primarily in legal aid, went to that school. I think it's at Port Arthur, that the high school, yeah. And you no doubt know, but maybe your colleagues from across the province don't know, that among the people from lived or born in what used to be called the Lakehead. It's an interesting story. I'm sure you know about how Thunder Bay got its name and not Lakehead. They had a ballot where they had the choice of three names: Lakehead, the Lakehead, and Thunder Bay. And of course, the votes were split by the Lakehead, and Thunder Bay ran up the middle. But it had some history to it as well. Bor-Alaskan was a resident. I'm not certain if I don't know. Yes, Bor-Alaskan was a resident. I believe he went to Thunder Bay. At some point, I'm not sure he practiced in Thunder Bay, and he may have been born there. I know his brother, Saul, was the first mayor of Thunder Bay, and you probably know that. You may not know that Bor-Alaskan and Paul Schaefer's father were very good friends. And Paul Schaefer's father, Bernie, was a bencher. And I had an extreme pleasure of being a bencher myself at a fairly early age of 35, and got to know Bernie Schaefer. He was a fine lawyer and gentleman, but he told me the story that I have confirmed with Paul Schaefer, who I briefly met at a funeral, that was a family story. What I don't know is why it was a story. So Bernie said when Paul was born, and I presume everyone has heard of Paul Schaefer, who is the music director for David Letterman. That show's been off for a while, so maybe not all of you have, but he's a famous Canadian musician, and there's at least one street named after him in Thunder Bay. But in the old days, of course, husbands, fathers weren't allowed into the birthing room, and when Paul was born, Bora Laskin and Bernie Schaefer were looking through glass as was the custom at the baby, and maybe a few babies born that they were sort of lined up in this viewing room, and Bora asked Bernie if he had a name, and he said, well, we're kind of going between Peter and Paul. And according to Bernie, Bora said, you should call him Paul because it'll look better on the marquee. And if you've ever watched David Letterman show, certainly near in many times, there were a number of different Letterman shows. It announced Paul Schaefer and the CBS Orchestra by showing a marquee. Why Bora Laskin had a thought that Paul Schaefer, and apparently they obviously did take the name Paul, would be a musician. There may have been music in the family. I should have asked Paul that. The funeral that I was at was for a woman named Marion Maloney, who was briefly, for about a year, a senator from, she chose Thunder Bay, although she was living in Toronto. Her husband was a Superior Court judge, and the family was very close to mine when they lived in Toronto. And it was a full church and a full reception in the basement of the church. And Paul Schaefer was surrounded by people who wanted to who recognized him and wanted to talk to him. So other than confirmation that was the story in the family, I should say that I told this story to John Laskin, who is not only a retired Ontario Court of Appeal judge, but it's probably little known to the Windsor students that he once taught courses at, he taught me civil liberties at the University of Windsor in the 70s. I believe he flew in to do that from Toronto. He was a practitioner at the time, and his sister Barbara was a lay bencher of the school, sorry, of the Law Society. So that's my stories about the Bora Laskin School of Law. The other schools don't have names attached. One law school is not represented here recently had the university changed its name because Ryerson came under criticism for his involvement in residential schools, and he was quite involved in education in early Ontario. I did not attend the University of Western Ontario Law School, but I did attend 2 years at King's College at the University of Western Ontario. Although I think, well, it says for some people UWO, I understand it's now officially called Western, which is could be a little confusing given that it's not in one of the Western provinces and is not even the most Western university in Ontario, but there it is. University of Ottawa was the school that educated my nephew and godson, who's named Matt Miller, and he's a lawyer with a personal injury defense firm in Toronto. I believe he's a partner there. I talked about Windsor, and now Queens is located right next to the courthouse I work out of. And I hope to be able to meet some of you at Queens at some point if my interest in legal education is taken up. Now, has the jury come back?
Your Honor, a note has passed to me that they anticipate about 10 more minutes for their deliberations.
Okay, so you as they say in TV, stretch. Or is there somebody else that is going to say something while I improvise on my feet? Osgood, I didn't attend there. I had a daughter who attended York University, and when I was in law school, the Windsor people just preferred to call Osgood the York University Law School because we were probably jealous. We were quite new in those days. I think we were after Ottawa and before Lakehead. That's my recollection. Windsor was a great place to go to law school and a great place to be a judge, and certainly looking forward to meeting the bar and perhaps the students at Queens. I don't know if I've left every. Is there a school that I haven't mentioned here? I think I've tried to mention you all. I should say, and I alluded to this, that the jury is not surprising they need more time because there was a high quality of advocacy by all of you, and the witnesses were certainly very believable. And given that you're law students and not actors, is there anybody who was a witness today who has actually got some acting training? No, you're just naturals. Well, I certainly, I've heard a lot of witnesses in a career that started in court in 1979, and you sounded like you had experienced what you were telling me about, and you sounded like victims. You sounded like bureaucrats when you were a bureaucrat. You were the bar owner, very, very hepped up about his bar, and the people who worked there. That was all very convincing. And the advantage, I think, of playing a witness is that as counsel, if you're involved in mooting, you're likely hoping that you will be court counsel as opposed to not going to court. When you've played a witness, then it gives you a bit of insight in how the witnesses naturally react to questions. And of course, you've been trained about the use of leading questions, open-ended questions are usually not used or are avoided in cross-examination because they're a gift to the witness. They hand you the ball and you can run with it. And some of you did that. And the closed question, I suggest, or just the very simple, I didn't hear too many of the I suggest, or but rather the better, the sky was blue, correct? Or it was dark, and you can build up a pattern of agreeable answers that is impressive and allows you then to harvest those agreeable answers in your final submissions to the jury. It's not wrong for, and it was commented on in this case, it's not prohibited to, when you're cross-examining, to be friendly to, as was the case in for a number of you who used your ability to cross-examine another defendant to get support of your client's position. However, it does leave open a suggestion, as was made here, that this friendly cross-examination is proof of the weakness of the defendant's involved case, or of almost a collaboration or of the two, and it allows you to perhaps suggest, well, their case is so weak that they're relying on another defendant to bolster their case. And all of that's fair. All's fair in war and trials. I was impressed by high level of courtesy by all of you demonstrated to the witnesses and to each other. And that's not always the case these days in real court. And I can't unfortunately say that the counsel that have appeared before me are always courteous to each other, or that they don't interrupt each other, or that they don't raise their voices. None of those things are good things, but it happens. And sometimes the longer someone's been a lawyer, the more ingrained some of the bad habits become. And you will know, or you should know, that judges in any, not just judges in the same court, but judges generally talk to, like everybody else, they talk to their workmates. And if a counsel gets a good reputation as clear, concise, honest, never gilding the lily, that reputation will be shared by judges with each other. Similarly, if council get a reputation for not being prepared, for being late, for misleading, or being a little slippery, that's a hard reputation to shake. And so I would emphasize to all of you who are intending to practice in court, remember that your integrity and your reputation for integrity is very, very important. And you must be forthright with the court at all times. If you need an adjournment because the reason for the adjournment should be true, and you can actually get in serious trouble for misleading the court. I'm sure you all know that, but always be direct and in answering the court's questions about something that you've said, and try to be forthright at all times and not kind of shade things a little bit, because if you do, that's going to stick on you. So I'm sure you're being told this by your coaches and by your teachers, your professors, but I can't overemphasize that. And courtesy to your professional colleagues and people that you meet in court, and of course, witnesses. All of you demonstrated courtesy and empathy. Some of you demonstrated empathy, which is important, not just with a jury, but it's important in the integrity of the system that witnesses, victims, plaintiffs feel that there's some sympathy and that this isn't personal. Now, there are, it's not to say there aren't false claims brought in court, and there's nothing wrong with, you'll find fairly quickly, and we didn't have any exhibits or videos, but in most personal injury cases now, at some point, if it's gone on for a while, the insurance company has sent somebody out with a video camera to watch the plaintiff take the garbage out, or go jogging, or some level of exertion that they may have suggested they were incapable of.
Your Honor, I see that the jury has returned back into the room.
Is there a foreman?
Yes, Your Honor, there is a foreman. The foreman's going to be Catherine Dempsey.
Hello, Your Honor.
All right. Yes, so has the jury reached a verdict?
Yes, the jury has reached a verdict.
And what is that verdict?
So our verdict is we found in favor of the plaintiff, and we have broken down the apportionment of liability as follows. As to Molson Canadian, 40% liable. As to the tavern, 25% liable. As to destructive construction, 20% liable. To the city of Bedlam, 10% liable. And to the defendant's giver, 5% liable.
Well, thank you very much. And we haven't heard too much about damages, but do I understand you have a verdict on damages as well? Or not?
I don't believe we came to a number, actually, jury.
I think we agreed that the ask of the plaintiff was reasonable at 5 million plus the costs. So those damages are,
and they'd be apportioned among the 5 defendants, as you've set out. Well, thank you. You've been a very good. I could tell you were all listening very carefully, and you've been a very good jury. And I hope you go home and tell people that it was a good experience. is my experience is that most people fear going to a courtroom and being called for jury duty, and that those who do get called have almost to a person enjoyed the experience. Occasionally there may be a complaint about one juror who was obstinate, but my experience over many years of talking to jurors or people who were on juries, while there is, especially in criminal cases, a bit, and I'm not sure it applies to civil cases, and I should know, but in criminal cases, there is a section of the criminal code that you're not to reveal what was said in the jury room. Somebody here may know whether there's any such prohibition on civil juries. I don't think there is.
Well, Your Honor, in this case, we actually need the jury to answer
Yes,
some more
I know we do
questions.
here. Yes. So should I invite members of the jury to further comments at this point?
Yeah, thank you, Your Honor. We also have an awards component to
Yes.
To the moot court that went before you today, and
Well,
the
I
jury.
will give the jury charge of the court at this point.
Thank you, Your Honor. So we have deliberated, and that took the bulk of our deliberations because we had a lot of good people appear before us. We thought that everyone who appeared from all these schools were exceptionally strong, and we say that year after year, but it's never less true. It's just our experience, and we know that they work very hard. So thanks again to everybody, to all the volunteers, to you, Your Honor, for dedicating your Saturday, and all of our sponsors that make it possible for us to do this virtually and next year in person. I will say before we get into the awards that next year will be Queens will be hosting, so we'll be up there next year, and we're planning for it to be in person. So I guess with that, we'll start with the first award. It's the Will Davidson Award for Best Opening Address. And the way we'll do this is each jury member will speak to the recipient of the team and just give some additional comments to that person.
Great. And I share, and you probably heard some of what I said, completely share your comments on the high level of advocacy and the witnesses as well. And it does get better every year. I can say that because I've been here once before.
Ivana, go ahead.
Okay, thank you. So the award for opening, I can just say yes, Mike?
Yes, go ahead and make your comments, and then we'll just move on to the next one afterwards.
Okay, so that's Chloe Carr from Osgood. Chloe, I thought, and I shared these notes on behalf of all the jurors as well. So you had really good organization, good pacing. You were obviously very confident, and you presented as very assertive. You were clear, and you kept things easy to follow, which can be really difficult with an opening. I thought you painted a really good picture. So I really liked how you called it a routine day, how she raced to catch the yellow light. I really liked that. But you still kept the details focused on the points relevant to your clients. You didn't clutter up your opening with irrelevant stuff. Other jurors had to say that you were loud, clear, confident, you had good pacing, and you empathized with the plaintiff, which is a great tactic. You got straight to the point, and you had good eye contact and good engagement with the jury. So really well done, Chloe.
Congrats, Chloe.
Thank you.
Yeah, good work. The next award that we're going to move on to is the Greg Monforton Award. It's for Best Examination in Chief.
And that award goes to Jessica from Osgood. And some of the comments about your chief were that you seemed very confident and comfortable, which I really appreciated, because I found as a juror, it made me trust you and your witness a little bit more. You kept things simple and easy to follow, which again, I think is extremely important for the jury, because they're just getting so much information throughout the trial. I think you got everything you wanted your witness to say on the record, which can sometimes be more difficult than it sounds. And yeah, I just really enjoyed, we all really enjoyed watching your watching your chief, and think you did a really great job.
Sorry, I'm speaking and I'm on mute here. It's like I haven't learned. And the next award, yeah, congratulations, Jessica. The next award is going to be the Bond Law Office Award for Best Cross-Examination. This was also a tough one, but I'm going to speak to it. The person who won this award is Tony Virgin from Queens. And the reason, we thought that you engaged really well with a lot of the ups and downs that came with your cross-examination. And that was the most true to life, because that's what happens, right? When we do cross-examinations, we don't always have friendly witnesses. The judge interjects, there's an issue on evidence. The the defense counsel, in our case, usually makes a comment, objects, tries to interrupt. The witness is not cooperating with us, right? We're calling it a glitch. They're calling it a desynchronization or something. It's the same thing. We know it's the same thing, but it's, they don't want to admit that. So we thought you overcame those hurdles with some type of composure, and that you kept on your points and you were able to circle back onto your script. And I thought you did a really good job, and so did the rest of the jurors. So congrats, Tony.
Good for you.
And the next award is going to go to.
Can I just ask you one thing? And I know I'm speaking out of turn. The Bond Law Award, is that out of Windsor?
No, it's Chris Bond. I think he's out of Trenton.
Okay.
Yeah, I think so, if I don't misspeak on that, but yeah. And so then there's the Bruce Hillier Award for Best Closing. And I think, Paul, you're going to speak to that one.
Yeah, I'll speak to that. And one thing I will say, what I observed about everybody is an incredible amount of preparation. Everyone exhibited that, and I think as a foundation to anyone who wants to do court work, it's preparation, probably 90%, and everything else flows from that. So everyone did a great job. It was tough to pick someone to do for the best closing argument, but we settled on Zachariah Warkington of Lakehead. We thought he had a really good demeanor. You had a good flow to your arguments. And I think what was really important is you're really able to kind of hone in and focus on your best arguments, and not sort of clutter up your closing with stuff that wasn't as strong. I think that's an important skill. So congratulations, you did a great job.
Well said. Yeah.
Thank you, Paul. Congrats, Zach. So the next award that we have to give is also a really difficult one, is the Best Overall Advocate. It's the Tim Boland Award. And who's going to speak to that one?
I'm
Mary,
happy to speak to that.
Yeah, thank you, Mary.
I want to first echo others' comments about how well prepared everybody clearly was for today, and articulate. You guys really did a great job, and I hope you enjoyed the experience. I'm sure you're enjoying having it finished at this point. And there were several people who were certainly eligible for this award. It is a tough one to pick from among you, but today we picked Tish Lewis. So Tish, you had the daunting task of starting off the day, and you did that though with like great sound, great pacing, very clear, did quite a good job on your opening. And in your cross-examination of the driver, you came across in a very natural way when you were speaking with your witness, or your cross-examining, and dealing with her naturally and conversationally. And just looking at my notes here, like bringing in the questions about the staffing of the restaurant and making a good point. I thought about the plaintiff's potential contributory negligence. I'm really winning the person over to your way of thinking because of the way that you handled the witness, I thought. And we all agreed that you today were our best advocate. So congratulations.
Awesome. Congrats, Tish. that's and so we're going to move on to the next one. Is the Berger and Clifford Award. This one is for best overall team, and we're going to have Megan speak to that one.
Yeah, so we found all of the schools were really impressive. It seems to get more impressive every year that we do this, and we're shocked that you guys are just in law school. But the decision that we came to was that Queens is going to take the award for best overall team. I'm going to echo some of Mike's comments about Tony, the cross-examination. I won't repeat, but we found it was really effective. And Melissa, your examination of chief, we found you had really good pacing, good tone, and you really were able to connect with the jury quite well. And we also found the witness, Victoria, was a very effective witness as well. So congratulations.
Well done.
Yeah, congrats to Queens. So yeah, next year we're going up your way because that's where we'll be hosting, and it will be in person. So we're looking forward to that as every year. Again, Justice Carey, thank you again for all the comments today and your patience and dedicating your Saturday to preside over this. And I think with that, unless there's any closing remarks,
Mike, we have the best witness has to be awarded by the coaches.
Oh, yeah. Look at that. You know, I said it in the jury room. I'll say it now. I've only been doing it 6 years. I forget the process.
That's why there's more than one of you.
Yeah, there needs to be.
It's support, just like the teams that we've heard from today. And I echo, since I've taken the mic, I echo everything that the jurors said about the various award winners. And it may be selfish of me to say this, but I would, if you're looking for a judge for next year in Queens and you're in person, my office is about less than 400 meters from the law school. So however, I know that there's probably other people that might be considered, but I enjoyed this in my previous involvement, and I would be happy to be considered if you are looking for a judge.
Thank you, Justice Carey.
It's going to be a little easy. It's going to be a little harder for to get as I did this time in Windsor. So I will be available if you're interested. Give me lots of notice, because I'm supernumerary now and I have big gaps when I won't be around. But thank you again for the opportunity. And on to the best witness. It's very hard, I'm sure.
Is there one of the coaches that can speak to the decision on the best witness?
I'm happy to speak to it. I originated this award about 6 years ago. It was as a result of one of my associates who passed away the year before, and she had worked on as a coach with me, and we decided that one of our biggest frustrations was witnesses which didn't stick to the script, and it really upset the competition when facts were being created by witnesses, and however theatrical they might have looked at it. And so the essence of the award is that you are someone who sticks to the information that's provided in the packages and gives the fairest chance for all of the participants to cross-examine and examine and put the evidence in. And so this year, I forgot now who we picked. Somebody tell me. Somebody ready? You know?
It was a tie between the plaintiff and the tavern.
That's right. That's right. We actually picked two because they were so close, and we tried to create numbers. Unfortunately, we need one more school, and then we'll have an odd number, and we won't have that. But I don't have any concerns whatsoever. I think in the spirit of the competition, to have two witnesses that everybody felt were being fair to the facts is a great result. And both of them, by consensus of all the parties. I mean, when we were picking them, we said, yes, I like this one more, but I agree that the other one stuck to the facts too. So we ended up with two, one from Queens, I'm going to say. Is that right? Help me, Osgood.
It would be Windsor, I believe, if it's the plaintiff.
Windsor
And
was,
Lakehead.
yep.
In Lakehead.
Oh, sorry, Windsor and Lakehead. But see, that shows you Queens was in the running too.
Yeah, good. Good.
Thank you.
Hard choice. Good choices. Very strong witnesses, as I was saying when the jury was out. And I wondered whether any of them had acting experience. And apparently not. They're just natural at being natural and obviously well prepared. And it's not easy to stick to the script when you're on your feet and being hit with cross-examination questions. And you really have had to study the facts to all of you, and those who didn't win. I mentioned the representative from the city. To me, sounded, and I don't say bureaucratic in a negative way, but sounded like somebody defending the integrity of their system, and would believe that the system was a good one. And of course, the plaintiff was very believable, had some trouble, both the plaintiff and the other, the driver, both were emotional, and we see that all the time. And it was a nice, I thought, a nice touch to do that. Obviously, you were acting, but that's what you are here to do. So, and all of the witnesses, I believed your sincerity in the position that you took. I've already commented on the, I think it was Mr. Brown, the bar owner. He was very, very convinced that his bar was the best bar, and his employees were the best, and very proud of his bar, and that is typical of many of the parties who are a little bit upset that they've been, targeted here. So well done, everyone.
Thank you, Your Honor. And the last thing, just before we let everyone go, or I turn it back over to Sean to wrap us up today, I guess, is that Otla just wants to remind everybody that also, you can always join the organization. For students, it's a free membership, so you can actually just join without any cost. And also, as an articling student, they greatly reduce what the memberships are. The membership costs are, I think it's under $100 for sure. So, and that gets you the full year of membership. So I encourage everybody to join Otla as a student and see what it has to bring. And then depending where you guys end up, to continue that membership through your practice. It's been quite beneficial to me and most of the board members on this call, I'm sure.
Can I put in a pitch? Can I put it, sorry, I interrupted you again. Mike, can I just put in a unscripted, unrequested pitch for that membership? Judges get the newsletter, which is an excellent newsletter. I've been involved in newsletters, including the Superior Court judges newsletters and my own law association, and going right back to high school yearbooks. And it's a high quality magazine, well written, and it usually has a number of articles that I read because it's called The Litigator, and I have the most recent copy on my desk. So if you can get a student membership, I highly recommend it. I'm not supposed to pitch for any organization, but I think this one since it's a professional organization, I think I'm all right endorsing it.
Well, we appreciate that, Your Honor. And the next litigator or the one coming up will report on the Otla Cup when all the winners and what happened here today. So be sure to be careful.
And there'll be pictures that you can show your family.
Yeah, exactly.
And prospective employers.
That's right. Okay, well, thanks everybody. Sean, do we need to do anything at the end of the day, or we'll all just log off?
I will end the meeting, and we will email a link to the video with edits for all the breaks in the next week in case anyone wants to look back on this. But thank you everyone for participating and working within the technical limitations of this. We really appreciate it, and we really appreciate the coaches that come back each year and provide so much assistance to these teams. It is an effort by everyone, and it's a great day to be able to do this. So thank you, everyone, and I hope everyone has a good rest of the week.
Take care.
Bye-bye, everybody.
Bye.